Testing, testing.
Test, 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 test. Test, 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 test. Check, 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 check. Test, test, test.
Oh, wait a minute. I'm going to get started. Tim Mallon. I'm a software developer and systems engineer with the Office of Government Ethics, and I'll be going over manual transmission of data required by PA 1501 and an introduction to the OGE extranet. Okay, so the first bullet I've covered, and then agencies who collect public financial disclosure reports in paper format, the good old-fashioned way, will begin using an application to do so where you'll be entering data by May 31st, 2016. The application is part of the new OGE extranet suite of applications, and I'm going to cover both that application and the extranet in general. All right, so there's just some basics as far as what the application is going to ask you to enter. It's going to be an agency name, reporting year, a reference date, that's the date that you're entering the information, the number of filers, the number of reports filed, and the number of reviews completed. The example screen is going to look like this. You're going to have agency, office, reporting official, reporting year, a lot of things, but you only have to enter just a few things because you're going to be logging in. And once you log in, we're already going to know what agency you're with, so that'll be filled in. If you are reporting on a sub-office, we'll already know that too, so that'll be filled in. We'll already know who you are. You'll have to select the reporting year. And if the report is unchanged from the last time you submitted one of these, you just have to click the unchanged box. Go on over to reference date, enter that, and click submit. If it's not unchanged, you'll need to enter a reference date, all the bottom row. Reference date, number of filers, number of reports filed, number of reviews completed. This is really just a snapshot. It's not cumulative. It's just going to be a snapshot as of the reference date. You'll submit that. That'll go into a system so we can see for your agency, a snapshot of your status. And then what is the OGE extranet? That is just a bunch of small apps, just like the one you just saw. And you're going to access those with a web browser or a mobile device. And the reason why I have the asterisk by a mobile device is because, smartphones are various different sizes. Myself, I got a really big one. So it depends on your screen size, how well you can see it. Some of the apps will be optimized for smartphone and some will not. But that app I just showed you, the one where you're going to be entering the financial disclosure information for paper submissions, let's say if you're on the way home on the Metro and you forgot to do that in the office, you can open that up on the Metro train, go in, enter a few things, click, if it happens to be unchanged, click that, and you could submit from your smartphone. Currently, the apps to the extranet will be distributed on an as-needed basis. So if you're someone who's going to be submitting or reporting on paper reports, you'll get a special link to the app that does that. Eventually, we're looking to produce a portal where you can go to a portal and you can go to the apps that you'll need to log into and the apps that you can just access directly. And the OGE extranet is created by federal employees for federal employees. This is not a contractor-operated site. Okay, the extranet's basically, it's a little bit of structure goes a long way. The extranet replaces, the good old, spreadsheet data call. I know we've all seen, where you've seen a spreadsheet data call that goes out to 100 people and said, hey, fill out this spreadsheet and send it back. And, you have to really take pity on the person who has to receive 100 spreadsheets back and collating all of those. I know most of us have all been there. It's a lot of work and it's a mess. It's very unstructured. The same with just emails. You see there's a data call and you get back some emails. You have to read the email. Is it complete or is it not? Who submitted and who is not? You really don't know a lot of those things. You're basically doing a business process, but in a very chaotic and unstructured fashion. By using the extranet, it adds just enough structure, to make all of that come together and reduces labor on both the part of the folks submitting and on OGE. And the scope of the extranet is really just going to be in that area there of the unstructured emails and spreadsheet data calls. It's not going to be a high security system. It's just going to be those things that were typically sent in the clear over the internet. And then the way the extranet works is there's two parts to it, an inside piece and an outside piece, and they come together using a synchronization process in the middle. There's no direct access, between the inside and outside. On the outside, you'll be accessing apps like, for example, if any of you signed up for a symposium session, you use an extranet app. OGE staff were able to see folks signing up for symposium sessions. They were also able to meter slots. There was a slot allocation. If too many people for your agency signed up, you would have gotten a message that said, hey, slots are full, you can't sign up. On the fly, OGE staff can go in and add some more slots so that OGE can interact with ethics officials on the outside, within a 30-minute time frame. All right, there's going to be apps where you log in and apps where you don't. The one I showed you about the reporting on paper submissions, you will need to log into that one. All of the communications will be using a commercial SSL certificates, similar to banking, where you have the little green lock, as I've got the example over here, encrypted connection. And this is different than what's happened in the past, where the spreadsheets and email are sent in the clear over the internet. When you send an email over the internet, that's just like a postcard going out over the internet. I know some agencies, I typically see it in DoD, send encrypted email, but that's kind of the minority at this point. Okay, extranet login. As I mentioned, the integrity app is going to require a login, and by logging in, it reduces the amount of data you're going to need to enter. You're going to be able to pick up organizations and know whether you've submitted a paper report previously, and it automates some of the compilation of data. We also will know who it is. Okay, no login. So I already mentioned the summit and symposium sessions. You went to the app, you filled out some information. It was encrypted with SSL, so it didn't go in the clear over the internet and didn't require a password. You're able to submit that. And as I also mentioned that, that app alone, instead of just sending an email to somebody like Kenesha or Nicole, they were able to see who was signing up and meter slots at the same time and not have to be the broker figuring out, which email arrived first and who signed up first. And it also, did other things like it provided the attendee list. When you came and checked in, that list that guy was looking at, that came out of that app. And the double asterisk there just means that, that was also looked at to make sure that we didn't let Mickey Mouse in the door. Okay, requesting an extranet account. Your desk officer will tell you if you need one, and you only need an account if you're going to use apps that require a login. And you're going to be going through your desk officer to request your account. Your desk officer is going to know who you are. That's the person who's going to vouch for you and validate your identity. And your desk officer will send you back your account information and temporary password. And the temporary password is where you're going to log in with your username is going to be your email address. You'll log in there one time, and then you'll immediately be prompted to change your password and enter your own password. Okay, the extranet in your mailbox. The extranet provides some limited outbound only email. If you signed up for one of the symposium sessions, you would have received an email back with your unique confirmation code. Also, if you filled out the annual questionnaire, you would have received back a unique link to your questionnaire. And that's through this outbound email service that we have. And the outbound email could also be used in the future for things like friendly reminders and gentle reminders. It's kind of have a mixed feeling about how that works. Some people don't mind getting an email reminder, and some folks, they get an email reminder, it's like honking your horn at them. It's road rage. But for the most part, I found that people don't mind getting email reminders, especially if it's based on like a time-based function where you owe a certain thing on a certain date, and you get a reminder 7 days in advance, and people typically tend to like that. And not only that, when you get an email reminder, you're going to get a link directly into that app you need to go to. You're not going to have to go to the OGE website, figure out what to click on, where to go. You can open up that reminder. There's a link you need to use that, and get out, you're done. Okay, so this is a recap. I definitely did not take the full half hour. And the extranet's basically it's a direct and process focused and common sense way to do what I call business process automation. A lot of these chaotic processes that we do just through sending emails, spreadsheet data calls, and all those things, the extranet's going to provide some structure. It's going to channel those things, and it's going to do some data validation. And again, this is only, the scope of the extranet is only on unstructured email, and again, the spreadsheet data calls that would be buried within those things. This is not a high security system. It's a system rated at what's called FSMA low, so it fits right in with what we normally do through email. It's not going to be an abstract solution looking for a problem or some confusing buzzword. And I included a very short list of buzzwords down below for reference. Okay, any questions? Yes.
So you're speaking in the future tense. I take it that this is not ready for us to get.
It's kind of like you can get your password now if you want, but the app is kind of in beta, and it's really not due out until May. Okay. So but definitely
set up the accounts.
We can do that now. Yeah, okay. That's all ready. Okay. Another question?
Are ethics officials encouraged to use their government issued mobile phones if they want to use the mobile process?
You should probably always, and the question is whether you should use your government mobile phone. You should always use your government equipment when you have it. And again, for most applications, the mobile phone works fine. I mean, nowadays the browsers are really good about expanding things, and you can also do the pinch to zoom. And I've got actually a smartphone that has a little stylus. You can use that. So for the most part, since these are external applications, you're going to be able to use your smartphone to do just about everything. Another question in the back?
Are there any issues with agency security systems? Do you need to go to your CIO office to allow your system to accept this app?
Okay, yes, we have. The question is whether you need to have any security controls changed inside other agencies, and no, you don't. This is an internet app. Anything you can do, if you can make it to the OGE.gov website, you can make it to these apps. These are extranet apps. And again, I mentioned the scope is within that space of email and the spreadsheet data calls. Just like email goes out over the internet, you don't have to ask to send us email. It's the same kind of thing.
required on, under, PA, whatever, 1501 with respect to reporting, information regarding the paper filing that CMDAE, that's who made the 31st? Is it just a one-time report?
No, this will be a monthly report. There's a schedule in,
Monthly report?
yeah,
Beginning May 31st?
I believe so.
The next one is June 30th? and then July 31st?
I've got it here in my materials, but it's out there. Yeah, the actual dates are listed in the advisory.
Simply reporting on where you are in the process.
Yeah, it's a snapshot. It's just where you stand at that day. You go ahead and submit, and boom, that goes into an OGE system so we can see for your agency where you stand.
What's the purpose?
It's explained in the advisory. You know, it's so that OGE can have some visibility over, you know, the report processing.
We get a response back from you?
We might probably send you an email receipt that said, hey, thank you.
That's it?
Yeah.
And then when we complete the process, we can end the reports?
No, it's like there's no end to it.
Every month we file a report?
Mhm.
Even if we've completed 100% review of all of the annual reports? we still must file?
I don't know. That's a good question there, because that's if it's unchanged, you don't have to. You know, all you do is click on change. So that's a partial answer to your question. But it'd be nice to have a checkbox that said we're done for the year. But then how do you know? How do you know? Like, say if it's in the middle of the year and you're done, and some new person arrives, and then you have to report on that person.
It's not required if your agency uses integrity. It's only required if your agency uses.
That's correct.
What about the T's? Is it going to ask about the T's?
I think it is the T's, it's annual terminations.
No, I mean, the periodic.
No, it's not for transactions.
Only for the annual report or
Yes, annual termination.
It's for 278.
28 E's? Okay, new entrant, annual, and termination.
Mhm.
Every month.
Yeah, I'm the app guy. I'll have to put up a screen up here. The app works.
It's a penalty for not using.
That's
Penalty for not-
it's the alternative to using integrity. It's just a different way to do it. You know, that way all the data can be accumulated, so OGE can see the status both in integrity and people doing the receiving paper reports. Okay, you answer your question. Okay, any other questions? Okay, well I think we're a wrap then.
For those agencies that want to transition to integrity, we can help us right here.
Test. Front row seats available. No, you're good. Okay. Just don't stick your hand out. Just don't put your hand out there. Good afternoon, everyone. My name is Jack McDonald. I work for the Office of Government Ethics in the Presidential Nominations Branch, and welcome to a refresher on mutual fund exemptions. As you know, we have a criminal conflict of interest statute, 18 U.S.C. Section 208, that prohibits government employees from participating personally and substantially in particular matters that will have a direct and predictable effect upon their financial interest. And the purpose of this criminal statute is to prevent government employees from having their personal interests influenced by government decisions. Now, while we have several options for remedying conflicts, such as recusals, divestitures, and in certain limited cases, individual 208 waivers, there might also be an exemption that applies to the situation. In those situations, the financial interest has been deemed too remote or too inconsequential as to be likely to affect the integrity of the employee's services. So today we're going to take a closer look at two of these exemptions for diversified and sector mutual funds. Now, just a few reminders about the exemptions. First of all, only OG is authorized to issue these exemptions. They can be found in 5 CFR Part 2640 of OG's regulations. They'll automatically apply to remedy a conflict, if eligible, unless you have a statute or regulation that would trump them. So keep that in mind. Often what comes to mind when I think of that is a prohibited holdings regulation or statute. And last but not least, the exemptions will both mitigate the conflict and any appearance concerns. Okay, let's take a moment to look at the analysis process we need to think of as we prepare to go through an exercise I've prepared today to look at momentarily. But you can see I've lined up a series of questions that we'll have to consider here. And these will work for any exemption, no matter which one you're looking at. First off, will the outcome of the government matter have an effect upon the identified interest? Can you identify a potential exemption? Does the exemption cover this type of financial interest? Does the exemption cover the type of particular matter we're looking at? And then where applicable, is there a de minimis dollar threshold of the interest that will be at play? And we'll look at that more closely in a moment. So for the purposes of today's presentation, I've selected a hypothetical example where we have an employee of the Federal Food and Drug Administration who will be working on reviewing and approving a request by drug companies. And you can see I've lined up a number of investments here from the employee's investment portfolio to take a close look at. First off, we have $100,000 invested in a Janus Emerging Markets Fund. There's $55,000 invested in a T. Rowe Price Health Sciences Fund, $20,000 invested in the Vanguard Healthcare Fund, and $75,000 invested in the iShares Dow Jones U.S. Consumer Goods Fund. So now, what do we have to consider? Let's go back to our line of questioning and our thought process here. First of all, will the outcome of the matter affect the holding? Well, here we're looking at the matters and the interests that are affected. We have drug approvals that are being considered, and the interests that I've lined up for you as an example today are pooled investment vehicles, mutual funds. Unless we can rule 208 out in this instance, we're going to go forward. So if we can't say definitively that there isn't a nexus between the matters and the interest at play, we'll continue on with our process. So which exemption might apply? Well, today we're focusing on the one that you would likely pick when you're thinking about pooled investment funds, which is the exemption for mutual funds, which is located in 2640-201. So a big question when we go to look at this mutual fund exemption is, do we have a mutual fund? Well, strictly speaking, we have a definition of what a mutual fund is in Part 2640. And you can see one of the first criteria is that it has to be a registered entity under the Investment Company Act of 1940. Now, those of you in the room who are experienced with mutual funds will know that if you're able to find a fund through research on, let's say, a Yahoo Finance or Google Finance website, and it's publicly traded, it's going to meet the test of being registered under the Investment Company Act of 1940. So I want to just assure you that that will cover a majority of the funds you'll be looking at. In, I'd say, rare situations where you can't locate a fund as publicly traded, then you would turn to the SEC's website. They have an EDGAR page, EDGAR, EDGAR, where you could enter the name of the fund there and see if it is in fact registered under this act. A couple more tips about mutual funds. From those of you also in the room that are experienced, you'll know that they'll have 5-letter ticker symbols that will end in an X. Okay. Now, for today's session, I've gone ahead and done the research for us, and this is something you already do in your offices every time you have a financial disclosure report in front of you. And I've gone ahead and looked each of these assets up for us, and you can see, hope you can see it well enough on the screen. The first one, the Janus Emerging Markets Fund, we found it registered, publicly traded. It's got a ticker symbol. We see there that one ends in an X. The next one, the T. Rowe Price Health Sciences Fund, same result. We see that this is publicly traded. Again, confirmation of the ticker symbol. And this is not only important for, of course, accuracy in making sure we're dealing with a mutual fund, but also making sure that your filer has in fact identified the correct fund on the report. Some of these funds have similar names. There can be multiple similar names within the same grouping. So you want to make sure you're looking at the correct name. The third one, the Vanguard Healthcare Fund, again, we'll check that one off. And then here's our fourth fund. Now, this one looks a little different to us, doesn't it? What do we notice that's different about it? Well, right, it's a little bit different. It's got 3 letters to the ticker symbol, and it doesn't end in an X. But I might have heard some conversation in the room. Does this look familiar to people as to what type of fund it might be? What do you think? Exchange traded fund, right? Excellent. And that's what that acronym after the word goods stands for, ETF, exchange traded fund. So they're not going to end in an X, and they're going to have fewer letters than the 5 letters that you see with the standard mutual fund. Now, just a word about exchange-traded funds. Most of these funds are organized as open-end investment management company funds or as unit investment trusts. They're going to be registered with the SEC in the same way that mutual funds are, and they're going to qualify for the same exemptions as mutual funds. So even though they have a slightly different name, they're represented by a different ticker symbol, we'll treat them the same for the purposes of the exemptions. Okay, now just a note of caution I wanted to put up here about the ETFs. ETFs invested in commodities and commodities futures do not usually meet the definition for mutual fund or investment trust. And I've put an example up here of a commodities fund for you to see. And the reason being is they're not going to be registered with the SEC under the Investment Company Act of 1940. They're going to be registered with another federal agency, the CFTC. Commodities Future Trading Commission. So just keep that in mind. You'll be using these exemptions a lot during the upcoming transition. You want to move quickly with these, have a really good understanding of how to apply them, and this will just be a really helpful thing to keep in mind that won't slow you down in your analysis process. Okay, so let's go back to a status check here and whether or not these met the definition of a mutual fund. We were able, just to recap, we were able to find them as publicly traded. They all were checked on the Google or Yahoo Finance site. I used Google today, but either one's fine, and there are multiple others I'm sure that you've used in your office. And we've been able to confirm that they are in fact mutual funds under OGE's definition. Okay, so our next big question is it diversified or sector? So this gets down to, does the fund have a stated policy of concentrating its investments in an industry, business, single country other than the US, or bonds of a single state within the United States? This will determine whether we're talking about a diversified fund or a sector fund. If there is such a policy of concentration, then we have a sector fund. If there is no such policy, we have a diversified fund. And one word about this concept here and this definition and why it's so important is as you go through your research of these funds over the course of time, occasionally you'll come across funds that will state in their summary that they're non-diversified. And if you actually look at the details, which we'll look at in a moment, you'll actually come to find out that they might be in fact diversified under OGE's regulations. So please remember to follow the definition as guidance in our regulations and not be swayed by the summary or the way the financial company might market it and promote the fund. Okay, now just a word along the way about accepted investment funds. This is something that we're all familiar with in terms of reporting. It's a mechanism and a reporting concept only, I want to stress, that allows for reduced financial disclosure of pooled investment funds. So just keep that in mind. We try to, anytime we can get this messaging in to help you, it's a message we repeat often, but it's a message that bears repeating and is so critical that it has everything to do with reporting and absolutely nothing to do with a conflicts analysis. So don't think of the E and EIF as exempt, it's accepted. And think of it, if it helps train your brain a little bit better, as just a mechanism for reduced disclosure. So it's really a reduced disclosure fund. So just keep that in mind, and you have to still forge ahead and consider your conflicts analysis and focus on whether it's a sector or mutual fund for those purposes. Okay. Now some guidance that I wanted to speak to and bring up with you today about sector and diversified mutual funds. Many of you are probably familiar with a legal advisory we issued back in 2000. It's still a great go-to document. It's about 16 pages in length, and it talks in great detail about diversified and sector mutual funds. Now, within that document, there are about 2 pages worth of examples categorized in both the diversified and sector categories of typical names of diversified and sector funds. I'd encourage you, if you don't already use that as a go-to resource, I keep it out on my desk all the time and look at it quite often to refresh my memory. It'll be great to have at your side during transition to help you kind of train yourself on which funds are typically in each category. Nothing's going to certainly replace looking up the funds and looking at the details, but over the course of time, as you get more experience, these names will just stick with you, and it'll save you a lot of time as you get practiced in that area. And then the other advisory I've put up here is one we issued last year that speaks specifically to real estate funds. And Deb Borteau touched on this at this morning's year in review, because after the 2000 guidance was issued, we took a closer look, and we have been over the years, but finally arrived at a policy we were comfortable with last year regarding real estate funds, in taking the position that we don't consider now all real estate funds to be sector funds. So when you look at that 2000 guidance, although it's still great guidance and will cover the overwhelming majority of the items you'll need to consider, just remember when it comes to real estate mutual funds, we don't consider them exclusively sector anymore. You want to take a look at what they're invested in. If it's typically a general real estate fund, a generic real estate fund, it's going to tend to be more now a diversified mutual fund. For purposes of the exemption, as opposed to a real estate fund that's going to specialize in a certain area of real estate, let's say healthcare or hotels and resorts, something like that, then that's still going to be a sector mutual fund. Okay, so now back to the funds that we are looking at today in this FDA employees portfolio. I've pulled up a summary here of each of the funds to just help us focus in a little bit more on their investment strategy. Now, the first one here, the Janus Emerging Markets Fund, there's a lot of great detail in here, but I just try to highlight a few of the keywords here. Investing at least 80% of its net assets in securities of issuers in emerging market countries. Does anyone in the room feel comfortable with taking a stab at what type of fund this might be, diversified or sector? Yeah, diversified. Thank you. Anything that you see that made you feel comfortable about going with diversified, or not see?
Emerging market countries, that's not focused on
Great, great. That's absolutely correct. We're not concentrating in those areas of specificity that I mentioned in the definition of sector fund. How about the next one? The T. Rowe Price Health Sciences. Here it's investing in the common stocks of companies engaged in the research, development, production, or distribution of products and services related to healthcare, medicine, or the life sciences. Sector, yeah. I mean, as you go on and get more comfortable with these, you might even just stop with the name and feel comfortable enough there. But for purposes of today, we definitely want to go to the limit and see the summary. The next one, Vanguard Healthcare, again, investing in stocks of companies principally engaged in the development, production, or distribution of products and services related to the healthcare industry. Sector. And now our last one we want to check on the list. This was the iShares Dow Jones U.S. Consumer Goods Fund. A few of the highlights here: tracking the investment results of an index composed of U.S. equities in the consumer goods sector. It seeks to track the investment results of the Dow Jones U.S. Consumer Goods Index. We see at the bottom there, they're putting in the narrative the fund is non-diversified. And just continuing on, there was a lot of information here, but it's definitely helpful for our consideration. There is the underlying index includes companies in a range of industry goods, and it goes on and it talks about autos and parts, beverages, food producers, household goods, leisure goods, personal goods, and tobacco. So what do we think about this one? Okay, good. So you didn't let that wording fool you down there at the bottom, which is good. You want to pay attention to the details, and remember, we're stressing OGE's definition and not how the fund financial company is going to characterize this. Okay. So now we'll get back to our status check, and we'll just give a summary of our results here. We see our two diversified funds are the Janus Emerging Markets and the iShares Fund, and then our two sector funds are the T. Rowe Price and the Vanguard funds, and they're obviously not eligible for the diversified exemption. Okay, now we get to our last question here, and this is critical to the de minimis thresholds. Does the value of the interest meet the de minimis? So with the diversified mutual fund exemption, we do not have a de minimis. We don't have to worry about that. But with the sector mutual funds, we do. So do we recall we had a number of different dollar ranges invested in each of these different funds? And we can see here, we do a status check on this, that we've got a couple of the funds in the sector area having different values. The first one being 55,000 and the other one being 20,000. So what's going to happen here? Well, we have to be concerned about that $50,000 limit. In what way? We talking individually or something else? Well, here we have to aggregate the funds. So we have to look at all the funds in the same sector. So here we've got two funds in this sector. In the healthcare area, we've got a $50,000 de minimis level that we can't exceed. So right here, we're looking at $75,000 worth of healthcare sector funds. So what would you recommend? Anyone would like to share their experience with a similar situation? What might you want to recommend in terms of dealing with this issue of now exceeding that de minimis threshold? We obviously feel good about the Vanguard Healthcare Fund. That's 20,000. That's well below. What would you do with the T. Rowe Price Fund? Divestiture, absolutely. And there's some flexibility here as to how you can handle it. Some agencies might be in favor of having an outright divestiture altogether. Maybe you're not comfortable with the filer holding anything in the healthcare sector, so you get rid of all the funds. Or maybe you have them just get rid of the bigger fund, or we could perhaps reduce that T. Rowe Price fund down to a a sufficient level that when coupled with the Vanguard Healthcare Fund, they would be well below the de minimis. And another good thing to think about, so we don't get concerned about the filer or the employee creeping back up towards the de minimis threshold, is getting some sort of commitment from them if they're going to stay in both of these, that they not make future purchases on these funds, and don't invest, for that matter, in any more healthcare funds if you're going to go that route. As things as they appreciate and value, absolutely, absolutely. So there's no magical number to get down to here, but I think knocking off perhaps at least 35 to maybe 40,000 worth of that $55,000 fund if you want to go that route. So, well, we went through that review exceptionally fast. We do have some more time for this session. So if there are any questions, I'd be happy to take them. Or if not, if you'd like to, feel free to approach me afterwards. I'd be happy to answer any questions as well. But I'd say other than the securities exemption, if you're new to ethics, the exemption for securities, other than that one, these set of exemptions are going to be the two most common you're going to look to. And I might just also say one other thing while we have a moment. If you have a situation where the sector or diversified mutual fund exemption won't work for you, and there can be a variety of reasons why it might not, probably the definition could be the big hang up for you, is that we have an employee benefit plan exemption, which is not part of today's discussion because we're just looking at mutual funds. But don't forget, if you have a fund that's in a retirement plan, to take a look at the employee benefit plan exemption. And Deb spoke this morning about some new guidance we put out on that in the legal advisory. So I just wanted you to have that in your pocket as well. So with that, are there any questions? Yes, Scott.
Jack, can you talk about Ocean's position and approach regarding geographic area funds as opposed to country funds? So, for instance, there seems to be a lot of funds that are called China region or China area funds.
Mm-hmm.
And I think if we dig a little deeper, they're not specifically focused on China as a country, as a region. What's these?
Well, yeah, I'd say I'd be hard pressed to answer that in a very broad sense today at this session. I'd just say take a look at the funds individually and see, but you obviously have to rule that in unless you can rule it out. And if there's some question as to whether or not it would strictly be a sector fund or not, I would just encourage to call us as you go through the nominee process, and we'll take a look at it individually. But generally, by and large, I think most of those funds are going to be on the side of being a sector fund. And yes.
So can you just look at it from the other way? Instead of looking at it from what you would have to do to reduce any risk, but let's say you were looking at this after the fact, and your agency person had already participated in a particular matter that involved a healthcare company.
Mm-hmm.
And then the ethics office discovers that he has this combination of funds. Can you just explain what you have to go through to see whether you have a violation? Does the company that he affected have to be in both funds in order, or can it only be
Well,
one?
no. Well, one thing I want to say just about that is we're in the before the fact business, not the after the fact business. So I think that gets me off the hook in a big way today. I mean, that would be a matter of, looking into it further and possibly a referral to the Inspector General of your agency to determine that. So anything in the diversified mutual fund, anything that's in the underlying, and there can be hundreds or perhaps drilling down thousands, usually only see the top 10 holdings, anything covered in the diversified mutual fund area, the employee can participate regardless.
Right.
If the sector fund holds something though, that's why we have to look at the certain amounts and the de minimis thresholds. Is that
Well, I guess
quite?
what I was trying to get at is, what if the company that was in question, there's one company that we're looking at, and we're trying to figure out if it's in either or both of those funds.
Mm-hmm.
If the company's only in one of the funds.
So let's say Coca-Cola, for example.
Yeah, just if it was
in-
a health science company.
Oh, hell, okay.
If the company's only you okay, or in order for there to be a problem, does that company have to be in both funds?
No, no,
Just it could be one or the other?
absolutely, right. It's not going to be a problem if it's diversified. It's only going to be a concern if it's sector. And if it's sector, then we're going to look at the thresholds. Right. So we have the underlying, the health sciences fund or the Vanguard Healthcare Fund. You're going to have perhaps pharmaceutical companies in there that could cause a problem. And if they're in there, then we're going to look to that de minimis threshold. So it's automatically going to trigger a concern, and then we're going to look to see what the value is. With diversified, you don't have to worry about that. There's no concern whatsoever with conflicts for values. And, as I mentioned in an earlier slide, this is going to mitigate both the conflict and any appearance concerns. So it'll take care of it all together. Yes, in the back? That's correct. If it's a healthcare sector fund and it's concentrated and your company's in that sector. Now, there's another consideration. We focus today on the de minimis threshold, but there is a prong to the sector fund exemption that says, let's say, for example, you are invested in a utilities fund and you work in an agency that's going to do an investigation of regional banks. And let's say that utility sector fund holds regional bank stock. You can go ahead and participate in that investigation of the regional banks because regional banks are not part of the sector of the utilities fund. But if they're in that sector, then we always have to look at the de minimis threshold. Yeah. Michael. Yes.
Would a certificate of divestiture have to be filed in that instance, or is it only if the entire asset is?
No, you can get a certificate of divestiture for any divestiture that's eligible, but just keep in mind, as we like to say, no second bites at the apple. So if someone will sell down below $50,000 and they want to apply for a CD and it's reviewed under the CD procedures and the CD is granted, if then the value of the fund goes back up over the 50,000 and the employee wants to sell again, they have to sell again to resolve the conflict, but they cannot come back for a second certificate of divestiture. Yeah. Okay. Well, thank you very much. I'm available afterwards if you have any questions, but thank you for your time.
Oh, test, test.
Testing.
All right, hello everyone. My name is Lee Francis. I'm an assistant counsel at the Office of Government Ethics.
And I'm Rachel Dowell. I'm an assistant counsel at OGE. And I'm also on details of the White House counsel's office.
My name is Monica Asher, and I'm also an assistant counsel at OGE.
Today we're going to discuss 18 U.S.C. 203 and 205. Those are two statutes that concern the private activity of federal employees. And they primarily bar representational activity, that is acting on behalf of another before a department, an agency, or a court. I'll also note and hope that we can be excused for using shorthand to refer to these criminal statutes. So I'll probably refer to these prohibitions simply as 203 or 205 throughout. So Section 205 has more prohibitions, so I'm going to tackle that first. I'll discuss a portion of the prohibitions and the elements, and then I'll turn it over to Rachel, who will finish 205. And then finally, Rachel will turn it over to Monica, who will discuss 203. Awesome. All right, first, just a quick overview of the structure of 205 and a summary of the other provisions included. So both clauses of A1, 205A1 that is, apply when there are claims against the United States. These are matters that qualify as claims against the United States are pretty limited though. So really the main focus for agency ethics officials is 205A2. That's usually the questions I get from my agencies and also when I get referrals from desk officers within OGE. We're going to parse out the elements of 205A2 in great detail. The restrictions in 205A generally apply to all federal employees, all employees of the legislative and judicial branches. I'll just note that it doesn't apply, however, to elected members of Congress. So moving through the structure of 205, next there is Section 205B, which basically applies the exact same restrictions of 205A1 and 205A2 to employees of the District of Columbia. And again, it's for claims for 205B1 and covered matters for 205B2. Executive branch employees do not need to worry about 205B unless they are employees of the Office of the U.S. Attorney for the District of Columbia. Those employees are special and subject to both clauses, both 205A and 205B. Next, we have 205C, which provides a special treatment for special government employees that is less restrictive. Rachel's going to touch on that briefly later. And then finally, we have 6 exceptions to 205A and B. And mixed in, we have the definition of a covered matter, 205H. So there are 3 offenses in 18 U.S.C. 205A that apply to employees of the government, not including employees of DC. Before we take a look at them, I just want to briefly discuss the purpose of 205, because I really think that when you get a tough situation or a tough application or a tough question, it really helps to understand why we have the statute in the first place in order to provide the type of advice that you would like. So the purpose of Section 205 is to protect the integrity of government actions by preventing its employees from using actual or supposed influence in support of private causes. Now let's take a look at 205A and its 2 prohibitions and contrast them with 205A2's prohibitions. So 205A1 only applies to, again, claims against the United States. So claims against the United States, are only claims for money or property. They're nothing more than that. For example, a lawsuit to compel an agency to issue or rescind a regulation or to interpret a statute in a particular way just would not qualify. A 1999 OLC opinion, on the other hand, makes it clear that a petition for attorney's fees is a demand for the payment of money by the United States, and as such, falls within the meaning of the phrase claims against the United States. So if there's no claim, there's no 205A1. Now let's look at 205A2, which applies to covered matters. Now the term is defined using almost the same language as 18 U.S.C. 208A with regard to particular matters. So you can apply in this context what you know about the meaning of particular matter as used and as interpreted by OGE in 208. Put differently, a covered matter for purposes of 205 would include matters involving deliberation, decision, or action that is focused on 1, the interests of specific persons, for example, grants, contracts, and litigation, or 2, focused on the interests of a discrete and identifiable class of persons, That would be a rulemaking or a policymaking. So from OG's own regulations, an example of a covered matter focused on a class would be a regulation establishing safety standards for trucks on interstate highways, or a policy regarding government loans to the owners or operators of small farms. However, covered matters, again, don't extend to the consideration or adoption of broad policy matters that are directed, again, at very large and diverse groups of persons. So those are general matters not covered by 208 and also not covered by 205. Okay. Before we get into 205A2, which is the heart of the presentation, let's just dive a little bit deeper into 205A1. So clause 1, like 205A2, only bars activity known as acting as agent or attorney. We're going to break that down in great detail, what that means, but suffice it to say for now, the prohibition in clause 1 is for the most part the same as 205A2. You need to be acting as someone's agent and make a direct communication to the government with an intent to influence. Put differently, almost anything that will violate the broader clause of 205A2 will also violate the narrower clause in 205. I'm sorry. Put differently, almost anything that will violate the broader prohibition in 205A2 will also violate clause 1 of 205A1. Just as a little explanation on this redundancy, when 205 was written in 1962, the drafters were worried about the Bergson case, which narrowed 205's predecessor, which was 18 U.S.C. 283, to only claims for money or property. Thus, the drafters added 205A2. However, when they did so, they decided to go ahead and leave in 205A1, clause 1, even though it in many ways was subsumed by 205A2. Now, moving on to the second prohibition, which is important because it is the only place in 205 that reaches behind the scenes activity. And so in that respect, it is much broader. But it's narrow in that it is, thank you, it only applies if you are compensated for your assistance in the prosecution of a claim against the United States. Thank you. All right, I thought it might be helpful just to map out the claims as they relate to particular matters and specific party matters. That is, as they relate to each other. So at the broadest level, we have matters, which are not covered by 205A at all. Then we have particular matters, or as OG refers to them, particular matters of general applicability. And then finally, we have specific party matters. And those are claims, and claims are one type of specific party matters. So let's look at a fact pattern to break down the prohibitions in 205A1. Okay. Excuse me. So George is an employee of a federal agency and attends law school at night. One of his law school professors is seeking damages on behalf of a landowner from the EPA, alleging that an environmental regulation that precludes him from developing his property as he wishes amounts to a taking of his land without just compensation. George's professor wants him to do some background research on the case, for which he will pay him an hourly basis. Is 205A1 going to apply to this situation? Let's look at the two clauses again. The key factor in determining whether 205A1 is going to apply is to determine whether there's a claim against the United States. In our fact pattern, the landowner is taking action against the United States, and it is a demand for damages or a demand for payment of money or property. He wants to make himself whole again. Accordingly, we have a claim here. So we can then go through the rest of the elements to see if it's prohibited. So clause 1, bars only acting as agent or attorney in connection with a claim, which requires a direct communication. Here, George is only doing behind the scenes research. Therefore, clause 1 would not apply, and for that matter, A2 is inapplicable. Now, clause 2, would he be receiving a gratuity or a share of interest in the claim? First, let's break down the term gratuity. It's a rather odd word to be used here because a gratuity is, well, gratuitous and not given as consideration. However, in the end, it has been construed as simply meaning compensation. That is, something of value in exchange for assistance. So George is being compensated for his case research in the form of an hourly rate. It's also possible to understand the arrangement as giving George a continuing interest in the claim. Again, so long as he continues to work on the case, he has an interest in the claim's continuation and in the expectation of hourly fees. So next is George providing assistance. Like we mentioned, the term is much broader than acting as agent or attorney, and almost certainly includes behind the scenes assistance like legal research. How far assistance reaches is not clear, and there's presumably some de minimis forms of assistance that would not be covered. For example, where the help is not significant and is essentially ministerial in nature. A good example here would be copying assistance. Georgia's activities are more than ministerial. So, yeah, sorry.
Would the U.S. does DOJ take the same view that gratuity is any compensation?
Yeah, sorry, yes. The question was whether or not DOJ takes the same position on the definition of gratuity. That is DOJ's definition, yes. Any other questions?
What about you doing research but get no pay?
If you do the research but you don't get paid, then you wouldn't have any compensation, and so the behind the scenes trigger would not apply. It wouldn't be prohibited. Anybody else? Okay. And it's clear, so Georgia's activities are more than ministerial though, and so it's clear here that the hourly rate is in consideration of or in exchange for the assistance provided. So the second clause of A1 would prohibit this activity. All right, so this is a new situation for 205A1, and I'll just read it real quick. Instead, the landowner seeks injunctive relief, requesting that the court rule that the EPA regulation does not prevent her from developing the land into a commercial property. The landowner does not seek money damages under a takings theory. Would this analysis be any different? Anybody want to hazard a guess? Not a claim I hear? Anybody else? Okay, that's absolutely right. There's no monetary relief here. It's not a claim, so 205A1 will not be in play. All right, now this is the heart of it, and this is 205A2. Let me just first go through all the elements of 205A2, and there are 7 of them, so bear with me. First, an officer or employee may not. 2, act as agent or attorney. 3, for another. 4, before a department, agency, or court. 5, in connection with a covered matter. 6, in which the U.S. has a direct and substantial interest. And 7, other than the discharge of his official duties. As we mentioned, 205A applies to all employees, with, again, a special narrow application for SGEs. The next element to be discussed is acting as agent or attorney. The phrase is a term of art with 3 layers of defined meaning. I'm going to go over the first layer, which focuses on the presence of actual or apparent authority. And I will then turn it over to Rachel to discuss the second layer, direct communication, and the third layer, intent to influence. All of these layers must be shown, but they are not explicitly listed in the statute, which makes it all a bit more confusing. So the first layer in many ways goes to the legal status of federal employees in relation to the person whom he is potentially representing. First, acting as an attorney is pretty self-explanatory, but it can be broader than typical attorney-client relationships. For example, it covers situations in which an employee would like to serve as a master amici, and that is a unique role in the Court of Veterans' Appeals, where you take on the role of attorney without actually being one. OLC, the Office of Legal Counsel in the Department of Justice, has said functionally, master amici would perform a role nearly identical to that of retained counsel. OLC thus concluded that the employee would act as attorney for the veteran. Now, while acting as an attorney is fairly clear, acting as an agent is a bit more complex and is represented on the slide by 1, actual or apparent authority. Now, actual or apparent authority is an agent. Those are agency law concepts, and so we're going to turn to those now. All right. So this is the heart of my section, and it's a little bit confusing, so please feel free to ask any questions if you have them as I'm going along. Let me just start by saying that in essence, what we're getting at here with actual or apparent authority is ultimately whether from the perspective of the government, the employee in his or her private capacity would be an agent when communicating to the government. Now, based on O'Neill, which is a Federal Circuit case at 220 F3rd at 1363, We know that an employee would be an agent of another when communicating to the government if the employee has actual or apparent authority. Well, that begs the question, what does that mean exactly? According to O'Neill and agency law principles, I will show you that it means that there are the three routes listed here to violating 205A2. I'll just read them very briefly. The first is the typical agency relationship. I think these are mostly the questions that we get, especially that I get when I'm talking about 205A2. Essentially, what you have is an actual agent's relationship under the common law, and then you have somebody, you have that agent acting within their scope of actual authority. And I included the definition here from the restatement third, and that's A, the principal has agreed that the agent should act on the principal's behalf and subject to the principal's control. And two, the agent agreed to so act. Again, that's the first route. So the second route is apparent authority. And what that requires is an agency relationship, but in that case, the agent is acting outside their scope of authority. And then it also requires the principal's action or acquiescence in some way. That's the second route. And then the third route is where there's actually no agency relationship, but the alleged principal, it wouldn't be an actual principal, the alleged principal does something or acquiesces in some way that leads the government to believe that, that they are speaking on their behalf as an agent. So those are great and abstract, but they can be best understood through the use of hypotheticals. So this is the first hypothetical, and I said, again, it demonstrates that first route where there's an agency relationship and the agent acts within his or her scope of actual authority. Under the common law definition of agency, we ask one, has the alleged principal agreed that the employee should act on the principal's behalf and subject to the principal's control? And two, has the employee agreed to so act? So I'll read the hypo very quickly. Government employee Andy works part-time for a Fortune 500 company as a financial analyst. And in that capacity, writes and sends correspondence to the SEC regarding an ongoing investigation of the company. So here the definition is satisfied. And it is also clear that Andy is acting within the scope of his employment as a financial analyst, meaning his employer has given him actual authority to speak on its behalf. Anybody have any questions here? It's a fair point. I haven't addressed that. If we knew which agency he worked for, we could determine whether or not there was an outside employment limitation in the supplemental regs, but luckily I left that out. I get the next one. Next. All right. Now I try to use the same hypothetical, but this one demonstrates another route where there is an agency relationship, but the agent acts outside his or her scope of authority. I'll read the hypo just really briefly. Same example. However, Andy works for the Fortune 500 company as an IT specialist. And on his own initiative, he calls the SEC, advocating for the dismissal of the investigation. It is clear Andy is an agent here, but in calling the SEC, he does not have permission to speak on behalf of his company. Again, he's just an IT specialist. Regardless of his lack of authority, if he advocates for the dismissal of the investigation, and the government believes he has authority to speak because he calls from a number that says his company, or there's some other indicator that he's cloaked with authority, there can be apparent authority there. Any questions on apparent authority? Okay. Finally, this third hypothetical demonstrates the final route. Andy, the same IT specialist, is serving as a contractor for a Fortune 500 company, providing technical support for a teleconference with senior executives. There's also attorneys and SEC employees that are there in the meeting. Andy makes a statement about the investigation. The company likes the statement, so the senior executives say nothing. So here, Andy's not even an agent of the Fortune 500 company. He's a contractor. So there's no agency, but his statement is made on behalf of the company and its senior executives. By saying nothing, those senior executives have acted or acquiesced to his representing the company. Where there is no agency relationship, but there is action or acquiescence by an alleged principal, and from the perspective of government, this alleged agent has authority, apparent authority can be present. All right, so I'm just going to return to this last slide that I showed before, listing these three routes. And just ask one last time if anybody has questions about these routes. Okay. Finally, and as should be obvious, the determination of whether actual apparent authority is present is really fact specific. I did it so that we all understood perhaps the farthest reaches of this element. So I'll end my discussion of this element by saying that when it comes down to the analysis of whether actual apparent authority is present, be prudent and conservative in the prospective guidance that you give to your employees. I'll now throw it over to Rachel.
Okay, well, so to implicate 205, you have to act as agent or attorney. And Lee really discussed the agent or attorney part where you have to have actual or apparent authority to act. But you also have to have a direct communication to the agency, as well as a communication with the intent to influence. And all three sub-elements have to be present to act as agent or attorney. So let's look at another example to kind of flesh out what we mean by direct communication and intent to influence. In this example, Julia is a CPA and an investigator who works on tax fraud cases at the Department of Justice. Her stepfather asked her to prepare his tax return for this year. So obviously we know she's an employee, so 205 could be implicated. She has authority from her stepfather to do this. But the question is she making a direct communication to the IRS? And is that communication made with the intent to influence? So starting at the direct communication element, who here thinks that by preparing the tax return, the direct communication sub-element is met? Does anyone have any thoughts on that?
Does she have to put her name in the form, identify herself?
That's a great question. She asked you have to put your name on the form when you're preparing, and that is a fact question that is not clear from this slide. So is she merely preparing using the documents her stepfather gave to her, or is she actually taking it and then signing as preparer? I think that is the key question here to whether or not there's a direct communication. If she's merely helping her stepfather prepare the returns and he's just going to sign, that's merely behind the scenes assistance and does not implicate this direct communication sub-element. If she's actually signing as preparer, she's putting herself out there as the person who signed the form and is attesting to the accuracy of the form, and then we do have a direct communication there. So that sub-element, assuming she's signing, is met. But what about the question of whether there's an intent to influence when you sign your stepfather's tax form? Any thoughts there? Saw some shaking back there. Okay, so from the back there, they said it was just a factual representation. And the question really is is this in connection with the matter on which there's some controversy or potential for divergent views? And the audience member was right. By signing it, you're merely attesting that the form is correct. You're not stating, you're not, representing whether or not the tax return should be, some certain exemption should be used. You're just saying that this is accurate based on what my stepfather gave to me. And by merely signing the form, there is no intent to influence there. Similarly, there's other forms out there like the SEC Form 10K and similar disclosures where you're merely just stating that this is correct based on the information provided. You're not putting out a statement of whether or not it's accurate or whether or not there's some legal basis for claiming some kind of deduction or things like that. So any questions on those two sub-elements?
The IRS would not know because it wouldn't be evident from the form. But what about if she tells her grandfather, hey, have you considered deducting X?
So if she asked her stepfather whether or not he should do one type of filing as opposed to another, for example, is that the question?
Deduct something, declare something,
Yeah.
whatever.
I mean, she could advise him behind the scenes, but by signing, she's merely attesting to the accuracy that the facts are there as provided. So those behind the scenes activities, while there is an intent to influence, those aren't being made to the IRS. Yes.
And that's true whether they're entitled to a refund.
Yeah, because all the tax preparer is signing is the accuracy of the form. They're not asserting the legal basis for the refund that's just on there. But what if the tax form is unaudited and one of the questions is whether or not they should get a certain refund? And Julia wants to defend her stepfather in that audit, that meeting with IRS officials. Clearly, we have a direct communication here. She's going to be in likely an in-person meeting. But what about the intent to influence element now? Lots of yeses. And I think that is, when advising an employee, that would be something you tell them not to do if they were going in to speak with the IRS. technically, arguably, it could be just conveying factual information in response to a factual inquiry. So there might not be an intent to influence element in all cases. Maybe they're asking, how did you get this particular number? And you'd be like, my stepfather gave me these documents. I added it up that way. But that could easily turn into kind of a dispute over maybe theories or positions about maybe what's the basis for claiming a deduction and kind of arguing why she deserves a deduction or maybe doesn't deserve a different one. So then that would create an element of dispute before the IRS. And I think there would definitely be an intent to influence there. So depending on what's discussed at the meeting, there's likely an intent to influence. Maybe there's a situation where she's merely giving a factual statement in writing and you could limit it to just factual information. But these in-person meetings lend itself to the likelihood that there is some element of dispute there. Now, yes.
Does OGE distinguish between being the tax preparer versus if you're the officer of a company and you're signing as the actual company?
So does OGE distinguish between being the tax preparer and signing as the officer of a company if you're filing your tax forms?
Correct.
I wouldn't think there'd be any distinction there if you're merely signing the tax form as preparer. The issue would come if there was more communication follow-up.
Right.
Yeah. One thing.
When you sign a form, a tax report, are you assumed to be in agreement with what is there, or you just happen to have a pen in your hand?
When you sign the form, you're merely attesting that this is accurate based on what you've been provided. You're not attesting you're not really going beyond that, if that makes sense. You're merely saying that based on what was given to me, this tax form is correct based on that information.
And that doesn't, you don't consider that trying to influence the IRS to go one way or the other?
That's not considered an intent to influence in that case. Yeah. I want to note one thing that we see this as Julia's stepfather. And some of you might be thinking there is an exception for certain family members where you can make a communication with the intent to influence that includes on behalf of your parents, your spouse, and your children. But that exception does not extend to step parents unless that step parent actually adopted Julia. So in this case, that exception wouldn't be available. Just want to mention that here. If it was her father instead, then she could probably use that exception to defend the tax return in the meeting. Okay, so with those three sublayers, an employee would be considered to be acting as agent or attorney for purposes of 205(a)(2). Any questions so far before we go on? Okay. Obviously, acting as agent or attorney alone is not enough to violate 205. You also have to act as agent or attorney for another. 205 does not bar self-representation. And also, you have to act as agent or attorney before a department, agency, or court. And it has to be in connection with one of those covered matters in which the U.S. is a party or has a direct and substantial interest. And finally, it has to be outside of your official duties to implicate 205. So let's look at a few more fact patterns and focus on those elements. Okay, in this next situation, Stephanie is a scientist at the National Science Foundation. At her previous private sector job, she supervised Jim, another scientist, and Jim is now applying for a position at NIH. He wants Stephanie to submit a reference for him to the NIH hiring officials. So running through the elements, we have an employee, Stephanie, she's at NSF. It's a direct communication. She's going to be, submitting this reference to the agency. Obviously, there's an intent to influence here. You're kind of telling them they should hire this person. It's before an agency. It's in connection with the matter which the U.S. has an interest. It's a hiring decision for an agency. So is this going to be problematic for Stephanie to do? Does anyone have any initial thoughts?
Isn't that within the scope of her functions?
Sorry?
Isn't that within the scope of her functions?
Within the scope of her functions. So she's, this is for a reference for an outside employee, not someone she works with on a federal job. So it wouldn't necessarily be in the scope of her duties.
Well, he's not part of it.
He's an outside, someone she knows from private employment.
Okay.
Yeah. Any thoughts?
In what way is Stephanie acting as an agent? She's conveying information. I know this person. I'm advocating on behalf of them because I know their work, but she's not acting as his agent for salary, for example, as we should in the past.
Yes, thank you. The question, the statement was she's not really acting as an agent for Jim, for anyone else here. She's kind of conveying her own opinions of him. And that's exactly right. She's not acting as agent or attorney for anyone else. She's merely talking about her experience, her opinions about whether Jim would or would not make a good employee at the agency. So it's merely a form of self-representation because Jim has no authority over her to say one thing or another, even though it helps him and she's doing it as a favor to him. There is no agency relationship for another in this situation.
Would it make a difference? It's assuming that the reference was in writing, that she decided to write it in a plain vanilla paper or in a paper with the logo of the National Science Foundation?
That's a great question. The question was, would it make a difference whether or not she writes on a plain piece of paper or one with the logo of the agency? And does anyone have any thoughts on that, whether or not that's an issue, maybe a misuse of position problem? I'm seeing some yeses. Well, actually, because the reference is for a federal job, there is an exception where you can use the letterhead to make that reference if it's for another federal job. And there wouldn't be a misuse of position issue there in that situation. There's a hand back there.
Would it make a difference if I wrote the letter for her, not the employee that wants to get the job, and I actually write the letter and she submits that to us?
She's still putting herself out there as her opinion, her representation to the agency as this is my personal opinion of the person. She doesn't have to do it. She has no, there's no requirement that she do that. But so I don't think that would make a big difference in this situation. Yeah. So again, this is, it would be okay under 205 and our misuse rules for her to take a piece of, I think it's NSF paper to make this reference. Because, we want federal employees to be referring good candidates to other federal agencies. I think that's the reason for that exception. Okay, new fact pattern. Henry, he's an attorney at the Nuclear Regulatory Commission, and he volunteers at the nonprofit Youth Athletics and Arts Incorporated, YA, in his spare time. Now, YA is seeking leases for a variety of facilities owned by states and local governments in the DC metropolitan area. Now, the question is, may Henry represent YA in lease negotiations with Maryland state agencies? I'm seeing some nods, yes. And I think this comes down to looking at what the definition of department, agency, or court is for our purposes in 205. Now, they're not actually defined within the statute, but if you look back to 18 U.S.C. Section 6, the general definition section, they do have definitions for department and agency. Department's pretty easy. It's one of those strictly federal departments. We could probably list them all if we needed to. An agency embraces only agencies of the United States. So that's going to include agencies in the legislative branch, such as the Office of the Architect of the Capitol. And it's likely to include agencies within the judicial branch, like the Administrative Office of the U.S. Courts. OLC hasn't expressly opined on that one, but I think that's probably consistent with the reasoning behind the legislative agencies. It's not going to include Congress, but it's also going to include executive branch agencies of the United States. So being only U.S. agencies, Maryland's it's a state agency. It's not included in our 205 prohibitions, and Henry may represent YA in this situation. But what if he instead wants to represent YA in lease negotiations with DC agencies? Any thoughts about whether DC is considered an agency or an DC agency is an agency of the United States?
Does it matter? Can the Congress have authority over them?
Well, so, DC is covered by 205, DC employees. That's something to consider. And it makes it kind of a different application sometimes than for states.
In other words, the U.S. party has direct substantial interest.
Mm-hmm.
A district of Columbia is subject to the local Congress. I don't know if it makes a sufficient substantial interest.
Yeah, so that could make make a really big impact if we do determine that this is a prohibited type of agency for Henry here. But actually, Congress actually separated the prohibitions, I think in 89, for the federal employees and made a separate prohibition for DC employees. And by doing that, they separated out the restrictions so that U.S. employees aren't restricted from going back to D.C. and vice versa. So OLC interpreted that separation as not including within the prohibition for executive branch employees representations back to D.C. agencies. So it's not considered a agency of the United States for 205 purposes here. And Henry can again represent YA in these lease negotiations with D.C. agencies. But let's say some disagreements arise about the terms of the leases, and Henry wants to represent YA in Maryland and DC courts. Now, we talked about the definition of department and agency, but the restrictions of 205 also go back to courts. And the term court, unfortunately, is not defined in either Title 18 or 205 itself. So this one gets a little trickier. Does anyone have any thoughts on how we apply this to courts?
Jumping ahead, the U.S. has to be a party in the administrative courts.
Okay, that's a good point. So she jumped ahead instead of even analyzing whether or not court is included here. She's jumping ahead to a different element and saying, you know, the U.S. isn't going to be a party or have an interest here. That is a great point, because that's a way to get out of a lot of the broad application of 205 is to consider whether or not the U.S. does have an interest in these cases. Going back to whether or not the D.C. and Maryland courts would be included in the prohibition, OLC actually concluded in a 1970 unpublished opinion that that was later cited in a public opinion that court means any court, state or federal. So the restrictions in 205 can go back to any type of court, whether or not it's at a state level or not. But the great point made there, what saves us a little bit is the U.S. still has to either be a party or have a direct and substantial interest in the matter. So that definitely narrows it a bit. What does it mean to have a direct and substantial interest in the case? So here at this lease disagreement, the U.S. clearly isn't a party here. It's not clear from our fact pattern that the U.S. is one of the, or I guess GSA isn't negotiating one of these leases. But how do we know whether or not they have a direct and substantial interest? And it's a very fact-specific analysis, and it can take a lot of work depending on what the issue is. You have to go to a lot of different agencies and consider whether or not they have an interest. And that would mean they have a financial interest in the matter, or it's likely to have an effect on their policy, programs, or operations of the agency. The agency might be involved in any proceeding associated with the matter, like providing witnesses or documentary evidence, or maybe they have just more than just an academic interest in the outcome of the matter. So there's a lot of different reasons why an agency might have an interest in a case, and it's hard to just assume that no agency does until you kind of ask around, go to Department of Justice, and they help you make that determination. For this type of case, here it's not clear whether or not the U.S. has an interest in the lease negotiations. At least on its face, it doesn't seem like they would, but you definitely want to double check that to see whether or not he could represent back. One last fact pattern with Henry here. Let's say that he's been granted administrative leave to represent YA in the lease dispute during office hours, consistent with the agency's pro bono policy. Now, by being granted administrative leave to do this, does that mean that his representations are being done as part of his official duties? Seeing a lot of different. Yes. Any other thoughts?
Because he's being paid during administrative leave.
Okay, so one answer is yes, because he's getting paid. You know, he's on administrative leave, but he's getting paid for that time, or he's representing. Yeah. Anyone else have any thoughts on this? You think no. Why do you think no?
I think no.
Yeah, so you're saying no because, you know, it's not, why would you be doing pro bono if it was all within your official duties? And I think for this one, I think the fact that you're on administrative leave is kind of a red herring here. It doesn't mean that you're doing it as part of your official duties. There is a difference between discharging your official duties and merely being allowed to engage in activity on official time. So when you're on administrative leave, that doesn't mean that you're doing everything as part of, you know, an assignment to you or as a part of your official duties. To fit within that, other than the discharge of the official duties, it has to actually have a supervisor making a factual determination of whether that activity falls within the scope of your duties, whether it's part of your job. And here, I don't think anyone's making that determination. They're merely saying that we're supporting pro bono activities. We have a policy in place that you can take advantage of administrative leave to go out and do private pro bono activities. It doesn't mean you're being assigned.
When they make their position description, they usually put at the end all the duties as assigned.
Sure.
And I'm assuming that here the supervisor actually asked the person, what is it you're gonna be doing? And then for whatever reason, they say, okay, we can give you the administrative. So isn't that implying approval of the activity?
The question was whether this is kind of implied approval of the activity by giving administrative leave. And I think the answer is no in this situation, even though it could maybe fit within this kind of general category of other duties as assigned. I think they would actually have to actively say that this is part of the job duties. And I think pro bono, traditionally in agencies, it's supported, and that's why that some agencies let you take administrative leave, but it's not necessarily assumed that you're doing it as part of your government duties.
And these then could not be used by the agency as part of the performance evaluation.
And it could not be used as part of the performance evaluation because it's not part of their official duties. I think that's correct. Any questions on those elements before we move on? Okay, a quick note on the special application of 205 to special government employees. As you know, an SGE is an employee who is appointed to perform their duties in less than 130 days in a year. They're generally considered an employee for purposes of most of the federal ethics laws, but the application of 205 and 203, I think, is the most important one to understand for SGEs, because these are people who have outside activities, outside jobs. Part of those jobs might be having to represent back to the United States. So this limited application of 205 is very, very important for your SGEs. Now, for SGEs, this is how the limited application works. If they work for less than 60 days in a calendar year, or expected to work less than 60 days, then the restriction of 205A applies only to party matters that they personally worked on. Now, that is much, much more limited than the restriction for general, regular employees. Now, if they work between 60 and 130 days, they're limited to both those party matters they personally worked on and any party matters that are pending at the agencies in the last year, at any agency they worked at in the last year. So it gets a little broader there, but it's still much, much more limited than regular employees. Any questions on that? We'll do a couple examples later on that application. And I just want to flag before we move on to 203, there are 6 exceptions to 205. We don't have enough time to cover them all in depth. I mentioned one about the parents, children, and spouses. There's 6 that are available for 205A. And now I'll turn it over to Monica to compare 205 with 203.
Thank you, Rachel. So the previous discussion of Section 205 is a really good backdrop for understanding the requirements of 18 U.S.C. 203. Because in many important ways, Section 203 tracks the language and purposes of Section 205, and particularly, as you'll see, Section 205A2, with its focus on representational activities in connection with particular matters. And it may be tempting to somehow collapse the two statutes or to conclude that one is overshadowed by the other. However, it's important to remember that there are differences in scope between the two, and these differences really are key, as you'll find out. So with that in mind, I'd like to provide a quick overview and summary of 203. In particular, I'm going to focus on 203A1B, which deals with employees of the executive branch. In short, it bars individuals from receiving compensation for any representational services rendered personally or by someone else when that individual is an employee in connection with certain covered matters. The restrictions in 203A1 apply to all federal employees and all employees of the legislative and judicial branches. They also apply to elected members of Congress. And you'll see that the rest of the chart looks somewhat familiar, other than this next one, 203A2, which creates restrictions for the payor. That is the person offering or providing the prohibited compensation. Next, 203B basically applies the same types of restrictions in A1 and A2 with respect to employees of the District of Columbia in connection with matters in which DC has a direct and substantial interest. Next, we have 203C. which provides that special government employees are subject to less restrictive prohibitions under the statute, just as they're subject to less restrictive prohibitions under 205. And then finally, we have 3 exceptions to the restrictions in 203A1. These are virtually identical to 3 of the exceptions in 205. Yes.
On the other price screen, for my agency, we have employees that are involved in payment of SSA. Social Security. And what for those employees who work in payment centers, et cetera, do they need to worry about 203A2?
So this, so 203A2 addresses giving giving prohibited or offering prohibited payments. So these are payments made by some sort of outside entity that would happen in like in contradiction to 203. They're payments that are not supposed to happen.
Well, they're working for the agency and they have some type of payment that they're still trying to receive, that they may have earned while they were in private practice. They still have some contingent interest in it, and they've applied for these attorney's fees, et cetera. And, you know, we have people in the agency, it's their job to pay, and sometimes they don't know that these people have any 203 issues. So would A2 typically apply to these things?
And you're referring, is she referring to the payor offense?
Yeah.
So I think that would be the discharge of their official duties. That's what they're supposed to be doing, is making those payments. So again, it goes to private activities. So I don't think it would be implicated there. The question of whether or not the person receiving it would violate is what we'll get to these next slides.
So the key difference that we'll see between 203 and 205 is compensation. Section 205 prohibits certain uncompensated activities, and for 203 to apply, the activity has to contemplate payment in some way. The employee doesn't actually have to accept or receive any compensation, as the statute also prohibits an employee from demanding, seeking, or agreeing to receive or accept compensation. Further, the statute does not cover all payments to an employee, but only compensation that is in exchange for the provision of representational services to a third party. This compensation can take I apologize. I think I skipped ahead. In fact, I'm sure of it. So what I want to talk about here is the similarities between 203 and 205. So Section 203, like Section 205, applies to officers and employees of the U.S. when they're acting other than in the discharge of their official duties. It covers representational services as an agent or attorney or otherwise for another person in connection with the same types of particular matters and before the same entities as in Section 205A2. And additionally, both 203 and 205 are aimed at preventing the abuse of actual or apparent influence with the government on the part of the federal employee. And now here's where I'm going to get into the differences between the two statutes. And we have a question.
Actually, maybe I'll just wait to see what you say about the differences.
Okay.
I think it's always been, I've always read the fact that 203 says an individual, whereas 205 says an employee, as being a distinction, and maybe that's a distinction without merit.
Okay, and you'll see why we say individual for 203 and not 205. As I was saying earlier, the key difference between 203 and 205 is compensation. And this is compensation that is in exchange for the provision of representational services to a third party. I just want to say that this compensation can take many forms. such as salary from an employer for providing representational services. It could be hourly legal fees from a client. It could be a contingency fee for helping someone win a legal case against the government. Or it could be a commission for helping someone obtain a government contract or other business with the government. So these are just a few examples.
Now, all the examples that you gave imply money. Now, can compensation be in-kind compensation?
For example,
They go to dinner, a trip,
Build a deck.
it has a value, but it's not money.
So the TED Steve. Yeah.
so I think there might be other
compensation,
issues.
I think, is
Yeah.
I think any compensation would qualify.
Mhm.
In kind, monetary services.
However, compensation does not generally include the reimbursement of expenses separately billed as actual costs, although such arrangements should be considered carefully and discussed with an ethics official.
If it is within the scope of your employment to provide the representational services, but at no cost, and then demand that you be paid to do it, for instance, like stewards representing somebody in an unfair labor practice, and they're supposed to be doing this uncompensated, but they demand compensation. Is this fall under that?
If it's
So-
is
so-
it in
sorry.
exchange for representational services?
Yes, but it's within the scope of their employment to do representational things. There are shops where they have occupational foods, but they are then demanding payment.
Sorry, so I just want to repeat your question. So you're asking whether somebody in their official capacity as a steward is supposed to do something and they do it, but they also receive money for it. So, I mean, that would sound like absolutely a 209 violation. What it would also constitute a 203. It's an interesting question because who's paying it? I mean, would it be the employee?
I mean, the represented party.
I've never heard of anything like that, but I don't know why it wouldn't also qualify.
And then finally, it's important to remember that 203 covers compensation received indirectly, not just directly. For example, an employee who shares in the overall profits of a law firm or lobbying firm may violate 203, even if the individual does not personally accept the fees from a particular client for a representation.
So are you saying that if you're a member of a law firm, you gotta make sure that the law firm doesn't participate in some action that can create profit for the law firm, and your partner may get some of those profits?
I'm gonna get into those sorts of issues later. I'm gonna try to get through the next few slides. I want to make sure that we get through all the content of this section. So I'm not going to take any questions for the next slide. But I think a lot of these compensation timing questions are going to be answered farther down the road in the presentation. So one way in which Section 203 is potentially much broader than Section 205 is that it covers representational services provided by someone other than the employee personally. This prohibition applies as long as the employee either directly or indirectly shares in the compensation for those services. So for example, if an employee is a partner at a law firm, the employee may not share in any fees received by the partnership for representational work performed by the other firm members before the government. This includes any kind of share in the profits of the firm engaged in providing such representational services, even bonuses that are tied to the firm profitability. So as a practical matter, it may be necessary for an employee to make financial arrangements with a firm to expressly exclude any share of compensation derived from the representational services of others. Note, however, that there is some case law support for the proposition that an employee does not violate Section 203 unless he or she knows that the compensation is attributable to the representational services of another before the government. So now we're going to move on to our first hypothetical where I think some of these concepts are going to be illustrated. So we have Valerie, who's an employee at the Department of Energy. She maintains an outside law practice with two other partners. One partner represents a client before the IRS in connection with an investigation. She would not be involved in that case and does no tax work, but instead works on real estate matters that do not involve the federal government. Her partnership share is calculated based on a percentage of the fees generated from all matters in which she or her partners are involved, including the IRS case. May she accept this partnership share? That's correct. So first, and we're going to go through the elements. Is Valerie an officer or an employee at the time the services are being rendered? Yes, she is. Would accepting the compensation be other than in the proper discharge of her official duties? Yes, it's her private practice. Would she accept the compensation either directly or indirectly? It would be indirectly. It would come from the client to the firm, to Valerie in the form of the partnership share. Is the compensation in exchange for providing representational services? Yes. And then finally, does it matter that Valerie is not personally representing the client? And no, it doesn't matter, because the main point of the scenario is that 203 bars employees from accepting compensation for the provision of representational services by someone else. So if she accepts this partnership share, based even in part on the partner's representation before the IRS, then she will be receiving compensation for representational services rendered by this partner at a time when she is a government employee. And then finally, we have a question.
So let's say she doesn't give these great fees, but the partner wants to give people shares, so they give more fees from another case. But money is fungible, so is that allowed?
You read my mind. So in that case, so what does the audience think? So she declines to take any share of fees from the IRS case, but her partners then offer her a larger than usual share of fees expected to be paid by another client in the near future. Can she accept this?
If the only reason for the larger share, if there is no other reason for a larger share, then
Right. So the correct answer is no. So arrangements that are designed to circumvent 203 are not permissible. So how can Valerie and her partners protect themselves from violating 203? They need to ensure that the firm maintains a bookkeeping system that segregates any of these prohibited fees from any permissible fees, and she should take her partnership share only from those non-segregated permissible fees.
now didn't you say that if she doesn't know, she can take it? The other thing they can do is don't talk to each other.
Even though there's some case law to support that, I wouldn't rely on that.
Yeah, I mean,
in
And the
practice.
question was, what if she didn't know?
Yeah, what if she didn't know?
I don't think you can ostrich, at least. I don't-
Yeah.
Yeah, I don't think the Department of Justice would think that if you tried to set up a situation where you essentially ostriched from whether or not you could find out and you're getting these payments that they wouldn't prosecute you or you wouldn't get in serious trouble, whether or not you violate 203. I don't think they would accept that arrangement.
Yeah, I don't think we would advise that.
Yeah.
Whether or not they would.
Yeah, whether or not they'd be prosecuted. Yeah.
So basically, we're saying if you know, should have known that.
Yeah, and also a law firm's not likely to do that because they would be prosecuted as well. So mostly they're also interested in making sure that they abide by the law.
So then what if, oh, sorry.
So this is a great place for me to clarify. Because of the way 203 is written, this says the word individual. So there comes a point in time where the fees that are coming in from representation against federal government have been generated in cases where the person was no longer an officer or employee. So after that point, they can partake in the whole share, right? This
So I think,
So we're,
yes. Oh, yeah.
Go ahead.
You're gonna get to that, right?
yeah, so in a couple slides, we're going to be talking about what happens for employees who are entering government and then also employees who are leaving government, and then the timing issue of when the fees are generated. Okay.
Hot
Are you also taking any other business from that client that got a good result in front the IRS, could be considered that the reason why it's now continue working, bringing their business to the law firm is because the good results with the IRS.
If it's
So, sorry, I'm misunderstanding your question. Are you asking if,
You have a client that the IRS, she did not get any of the fees.
but because she works there, they continue to get more and more business?
But then now you continue to get more and more business from that client because of the initial work you did for him from the IRS.
I mean, if they didn't receive any payment for the prohibition for providing services before the government, if they didn't receive the compensation for that, this individual, then the fact that they bring more business to the firm,
So the other
it wouldn't
ones are
violate
okay.
203. Yeah, they wouldn't violate 203.
And the last point I want to make here is that if Valerie were an associate or of counsel rather than a partner and received a set salary rather than a partnership share, generally the receipt of a set salary would be a permissible means of avoiding the 203 prohibition. There are ways in which the set salary could be problematic, and that's basically if the salary had been agreed upon, there was some sort of mid-year increase based on an increase in the firm's profitability, and there was no deduction for receipts based on representational services that would be prohibited, the compensation for which would be prohibited under 203. And now I'm going to be discussing timing, which I know a lot of you want to hear about. So this is a huge difference between 203 and 205. And again, this goes to the individual versus employee. So as I mentioned earlier, when representational services are rendered or to be rendered at a time when that individual is an officer or employee, then compensation that is in exchange for the provision of those services is prohibited. However, if the representational services are rendered or to be rendered prior to the individual entering government service, then the compensation that is in exchange for those services is permissible. Similarly, if the services are rendered or to be rendered after the individual leaves government service, compensation is also permissible. So note that employment status does not matter under Section 203 with respect to the timing of the actual payment sought, received, or agreed to be received. So again, the takeaway is that compensation is prohibited if the individual is an officer or employee at the time the representational services were rendered.
The to be rendered, that was before the appointment, that means that the firm got a retainer before you went into the government, and then you're working through your retainer while you're in the government employment. But if the firm already got the money, I'm not sure how the to be rendered works before the employment.
Yeah.
So the question so there's a clause that says that if you receive payment for representational services to be rendered while you're a government employee, I think the only situation where that would really come in is, where before you go in, you agree to represent, or your firm agrees to represent somebody while you're in the government, and they give you payment for that. I think that's the cleanest. Yeah, I think that's the cleanest. If they paid it ahead of time, or they gave some retainer and they gave you money and you received it before entering government. For the record, I've never seen a pre-employment application prosecution under 203, either in published cases or through OGEs to prosecution survey, but it's there and it's possible.
So our last fact pattern discussed how 203 applies to a current employee. It's important to note that 203 also has implications for individuals who are entering government service. On the prospective side, it is generally a crime for an individual to receive or agree to receive compensation even prior to federal employment if the compensation is in exchange for later representational services to be rendered when the individual becomes a government employee. So a special word is in order about another important timing issue, which involves contingency fee arrangements. So attorneys who are entering government from private practice sometimes arrive with a contingent interest in cases involving the government. Under a typical contingency fee arrangement, the attorney agrees to represent a client in exchange for a certain percentage of whatever amount, if anything, the client ultimately recovers. The problem is that even if an attorney stops personally working on a contingency fee case upon entering government, some other attorney presumably has to pick up the ball and keep providing the representational services, which are going to occur during the employee's period of government service. So the longstanding view of DOJ and OGE is that prior to assuming federal office, attorneys have to find some way of disposing of all interests in contingency fee cases involving the government. The reason is that the contingency fee, by its very nature, is compensation for all representational services provided in the case up until the point of payment, including those services that are provided by another attorney after the first attorney joins government. So there are a few options for disposing of contingency fee arrangements. These including liquidating the employee's share and converting it to a sum certain that is not contingent on the outcome of the matter. Additionally, under carefully limited circumstances, an employee may assign his or her interest in a contingency fee to another person in a case in which the U.S. is a party or has a direct and substantial interest. OGE 99X20 sets forth these conditions as follows. So a permissible assignment of a contingent interest must be executed and effective prior to entering government service, must be complete, unconditional, and irrevocable, must not be made to the employee's spouse, minor child, legal dependent, or household member. And 4, must not permit the employee's involvement after entering government service in determining the amount of the fee. So in a case where the contingent interest is in a claim against the U.S., would compliance with the 4 conditions also ensure that the assignment passes muster under Section 205A1? And here we can't be sure for various reasons. And given the lack of clarity on this point, we strongly encourage you to consult with OGE prior to providing advice on assignments of contingent interests in claims against the U.S. So now we're going to move on to a hypothetical that illustrates some of these points for an employee who's entering government service. So we have Jacob, an attorney who's leaving his personal injury practice to join DOJ. In his private practice, he has one Federal Tort Claims Act case against the VA. His retainer agreement calls for him to receive a 30% contingency fee, in addition to reimbursement for his litigation expenses if his client is successful. All depositions and other pretrial discovery and motions are concluded, but settlement negotiations are ongoing with the possibility of a trial in the future. So may Jacob continue to handle this case after he joins the government? That's correct. I'm hearing some no's. Section 203 clearly bars him from continuing to handle the case, since continuation would involve representation of his client before the government while in office, and all of the elements of Section 203 are met. So may he hand the case over to another attorney while reserving the right to a pro rata share of any contingency fees ultimately received? Correct, no. Section 203 would bar this arrangement. Under the arrangement, he personally would not be performing representational services while in office. But remember that Section 203 does bar representational services rendered personally or by another. Okay, so may he assign his right to receive his share of the contingency fee to his spouse? Correct. Even if you hadn't seen that previous slide, something just doesn't seem right about this this arrangement. Assignment to a spouse would not be permissible.
The question was
whether
they
he could
assign
assign it to his parents. That is not one of the listed entities that would be prohibited. Although I think in that case you would still strongly be urged to consult with OGE as to whether that would be permissible. So next question, may he settle on a specific non-contingent sum in lieu of a contingency fee prior to joining the government? Yes, that's correct. So may he retain a contingent interest in the recovery of litigation expenses advanced prior to entering government service. So filing fees, costs of medical examinations, phone charges, and so forth. Yeah, so I'm hearing some agreement. So retaining such an interest in litigation expenses during federal service is permissible under 203. So as OLC has explained, 203 covers only payments given in exchange for representational services. Since an employee's recovery of expenses advanced on a contingency fee basis can't properly be characterized as being in exchange for representational services, it is not barred by 203. And I'm going to move ahead so that we can get through employees leaving government. Because the timing aspect also has implications for employees who are leaving government service. It's a crime for an individual to receive compensation after terminating the federal employment if the compensation is in exchange for representational services that were rendered while the employee was still in government. And this situation is going to arise most often with attorneys who leave government and join private law firms. Firms sometimes compensate their members, especially partners, on the basis of fees received for past representational services provided by the firm, including services that may have been rendered during that period when the former employee was still in government. So in these cases, the former government employee has to make arrangements with the firm to avoid sharing in any prohibited compensation. Such arrangements might include, for example, agreeing to receive a fixed salary for a certain period of time. And then we're just going to conclude with an example. Jane left the Department of Health and Human Services to become part owner of Government Strategies, LLC, a government relations and consulting firm. While she was still in government, the firm began representing a coalition of state governments in their efforts to persuade HUD to modify its requirements for community development grants. Shortly after she joined the firm, the coalition paid its first bill for these services. So may Jane share in the fees generated by the HUD work? That's correct. She may not. Again, she cannot share in the fees because they're in exchange for representational services rendered by another while she was a government employee. So if she were a salaried employee, could she receive a bonus that was based on the firm's profitability for the calendar year in which those fees were received?
Unless she got a deduction based on the part of the profitability that came from that company.
Right. So she would not be able to receive a bonus that's directly based on a percentage of the firm's profits because she would be receiving compensation for representational communications before HUD that occurred during her government service. So as such, that bonus, as described, would be barred by Section 203.
But assume that that is not the only work that that firm is doing. And that specific work represents 10% of the profits of that company. Can she receive a bonus minus 10%? Assuming direct proportionality, of course.
We're happy to field questions afterwards. I'm just going to try and let Monica finish
let me
up,
just
and then
get
we're
through.
happy to speak to you about any other questions you have after. Unless that's it, we can.
And then finally, may Jane share in any future fees for additional services rendered in connection with this matter? Right, so I'm hearing some yeses. So as long as the fees are for representational services provided after Jane left the government, Section 203 is not an impediment.
I'll finish off with just like 3 more key differences. One, there's a payor offense for 203, not for 205. Practical significance is that law firms often have programs in place to wall off certain fees to employees. Second, 203 is arguably broader than 205 because it says act as agent or attorney or otherwise, while 205 is only act as agent or attorney. In practice, I don't know what type of situations this might cover. I haven't seen that play out, but that is something to keep in mind. And finally, 203 applies to members of Congress, while 205 does not. Practical implication is more cases out there with 203 because of that. I think on that note, one other flag is that the SGE limitation is there for 203 as well. So the limited application applies the same way as 205. So thank you all for joining us, and we can answer any questions.
Yeah, we can answer Oy.
I have to rush off to my
touch.
Test, 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 test.
Nice to meet you. Sam says wonderful. Oh, Sam's the best. He is. He's the
Tim, yeah, so good, so good to see you. Yeah, all right. Yeah, absolutely. Co-star, yeah. Okay. Okay. Yeah. And you know, on the desktop, I don't know, who do you work for? I mean, actually, you don't have to, you can't tell me, you can't tell, but, so I mean, on the desktops are for agency as well, so. Yeah. Right. Okay.
Yes.
So, you know, it has to see there. Yeah, yeah. Oh, really? Oh, it's like that? Oh, okay. Oh, okay.
Yeah, you're good.
Okay.
Out of time. Huh.
Okay. Okay.
Thank you, sir.
You're welcome.
Now, you'll see that the mystery.
Restart. Like 55 in the last one. Yeah.
Oh.
She has like all these like animation
Oh,
things.
she has animations, yeah.
Clickings and then like everybody's like interrupting her. So like then they were like questioning and like everybody's jumping in and the mess. Everybody else has been really easy.
That's good. What were they talking about?
5.
I'm glad you come today.
Huh?
I'm glad you come today. You get a sense of like what we actually do.
Yeah, I was like listening to it. There's lots of questions about it.
The answer is it's complicated.
Yeah, one lady about like taking compensation for things. I know one lady. They come and build a deck at my house. Like that's all. Still. They're all standing there and we're just like, is it still filming? I was like, no. It's pretty.
Yeah.
Yeah, I had this up, but this still had the PowerPoint. Everybody was like in here, thought it was still taping on. I was like, no, it's on PowerPoint. Are they doing the auditorium? They have more in the auditorium. Oh, there's more everywhere. Getting nervous. Yeah, you get all the time. Yeah, they were all nervous. They were like,
My job.
Cheryl presented today?
Yeah, she and I just did a class. Second time.
Busy man, busy man.
Yep.
A lot closer to 6 or 7. Make sure I get my truck like that back. So this week we leave how nice and warm it's gonna be when we're at work. It's gonna rain on the weekend. I know. Well, Saturday's gonna be okay. Sunday it's supposed to rain.
I can play golf in the rain. Golf tournament. So slow.
not going to be in Florida.
Oh, like,
While in Florida, it's in Sarasota. It's only like an hour and a half.
Yeah.
So I would drive. Hickory Grove tournaments and play with wooden shafted clubs.
Oh, wow, that's cool.
1900.
That's cool. Oh, wow, so cool. Are you gonna wear like, you gotta get like an old school outfit. That would be awesome.
You're supposed to. You're not required to, but you may.
You should. If you don't, you guys that didn't do it, like the not cool guy, should take it out. When you leave your vacation?
Monday. So I'll be in the office Friday, and then I'm going.
Oh. Is Keisha back tomorrow?
She has the flu, so
Oh, jeez.
maybe not.
No. That's, yeah. What do you think? Thank you.
All right, good afternoon. Thank you guys for coming to the last session of the day to talk about enterprise risk management. My name is Patrick Shepard. I'm a senior instructor at the U.S. Office of Government Ethics, and this is one of my favorite topics to discuss. And it's actually finally going to be timely. We've been talking about enterprise risk management at OGE for 3 or 4 years now, I think. We've been saying, you know, this is coming, this is coming, this is going to be important to your programs, it's going to be important to your agencies. And I'm very happy to report that very, very, very soon, the guidance is going to come out and your agencies are going to begin working on enterprise risk management. So this was just from last week. GovExec reported that OMB is positioning the federal government to integrate enterprise risk management into their transition plans. So it seems a little strange to discuss enterprise risk management in the context of a transition-focused conference summit. But really, this is going to be an essential part of the change in leadership after the election. So it looks like what OMB is going to ask agencies to do is to begin implementing the enterprise risk management principles and programs at their agencies so that agencies are prepared with a portfolio view of their risks for the new leadership. So this is sort of a legacy item for the Office of Management and Budget and for the President. So this is really, really a timely discussion of enterprise risk management. And it's really important to us as ethics officials because you may not think of yourself as a risk management officer, but you really are a risk management officer. We protect our agencies every day from several kinds of risk. We protect agencies from reputational risk. We protect our agencies from legal risk. And we protect our agencies from material risk. When things go wrong, you have fewer resources and you can have real, sort of material problems. And these have been messages that we've been talking to OMB about for a few years. You can see them reflected in their A11 circular, which was published last summer. And I believe you will see those when A123 comes out in the next 6 to 8 weeks. So we're going to be watching this. We've been watching it, and we're looking forward to sharing with you the guidance from OMB as soon as it gets out. But the other thing we want is for you guys to be prepared and knowledgeable when these initiatives begin so that you can meaningfully contribute to the exercises at your agency. So I want to start with a question. Before we get into what enterprise risk management is and how we do it and all those things, what is our role? What role do we play as leaders of agency ethics programs? What is our purpose and what is it that we're trying to accomplish? Anyone have any suggestions? Yes, please. Yeah, no, there's a lot of answers to this question. Okay. Okay, so you have sort of two things. We want to make people aware and able to make better decisions. You want folks to feel good about them. And we want that to contribute to a culture of honest service. I think those are great places to start. That's definitely part of our role as an ethics program leader. Yes, please. Absolutely. So we have program stewardship, right? We have to make sure that we have the things we need, that we're planning for the future, that we know how to address the challenges that are likely to arise. So yeah, those are absolutely things we need to do. Yes, please. Yes. Okay. Okay. So that's great. So before you came to ethics, you were involved in succession planning at your agency. So you realize that while it might have been absent in the one instance, ethics should definitely be involved in the larger agency programs. Yeah, absolutely. As program leaders, it's essential that we participate in those agency-wide initiatives. Definitely. Other things that we're responsible for. Well, here's a question. Maybe make this a little more specific. Who do we protect as ethics officials? We protect the agency, certainly. So our job is to protect the agency from certain kinds of risk. Who else do we protect? We protect the general public, right? We're in charge of their resources. We're marshaling their programs and their government. So we make sure that their programs are working for them. Absolutely. Who else do we protect? We protect employees. So we have a big role when it comes to managing risk. We manage risk for the entire organization, for employees individually, and sort of the reputation and effectiveness of the government as a whole. So that's a big, big job. And I think that's something that enterprise risk management principles can help us to sort of understand and begin to manage effectively. Okay, so now we can talk about what it is. What is enterprise risk management? I'll just give you guys a few minutes to read this quote, and then we can talk about it. So it seems like you guys had actually a really good sense of what it is we're trying to do here. A lot of the elements of our discussion that we've already had today are reflected here. Notably, it's that we participate with the whole organization to protect the organization, that we take a portfolio view that allows us to work with ongoing initiatives and contribute to them meaningfully, that we observe challenges as well as opportunities, and we use them in an enterprise-wide way. And I think this is one of the biggest things that we want to communicate through this session and through all of our sessions on enterprise risk management, is that we want you to participate as a member of a team in your organizations to manage risk across the organization. So can you guys give me a sense of who you might need to work with or who in your organization can help you participate in those discussions? Does anyone have sort of a sense of that or have programs in place already? Yes, Deb. Yep, absolutely. So there are some people who are really interested in this in our organizations already. We have our chief financial officer. They have a risk portfolio that complements ours. Audit committees, those people who conduct internal oversight and manage internal controls. And who was the third one? Oh, yes, and the internal controls folks. So your performance officers, the people that manage the performance of your organization, who manage the risk, who manage the finances, they're going to be partners in this kind of process. The CIO, the chief information officer, is also someone who's going to be involved in this process. And you can see how the ethics program fits into that. Who is engaged with their procurement folks on a sort of semi-regular or regular basis? Yeah, those are people who address risks that are complementary to the ethics program's risks. We can support them. They can provide us information we need to do our jobs. So what we're really thinking about is getting outside of the ethics office, looking across the organization to see where the risks are arising and see how we can contribute to identifying and addressing them. That's a lot of work for us, but the nice thing is it also provides us some help. The CIO, the CFO, the internal audit folks have information that we need to be effective. So we want you to engage with those people so that you have the information you need to protect your agency. I'm going to talk about a couple of models for how we can look at our work. And this is not the best model. So there's sort of two ways that you can think of the ethics program. You can have an ethics program of, by, and for the ethics program, where we seek policies and activities to protect the program and its operations. Or we can take a perspective where the ethics program works for the entirety of the agency. And that's what we're really talking about. That's the change in view, is we don't do the ethics program to have done it. We do it to have protected the programs and operations of our agency, to effectively manage risk, to identify risks, and to find opportunities. So when you think about your work, think about how best you can make that work serve and protect the entirety of the agency, and think about whose help you need in that process. So that's kind of the change in thinking that we want to help you see and help others in your organizations to see. A lot of it is communicating this to the others in the organization, that we're here to help manage the organization's risk. We work with you and for you. So how do we do that? Does anyone have any thoughts? What kinds of things could we do? What are some first steps we could take to help our organizations manage risk? Yes, we'll see. Right. That's a fantastic suggestion. So we want to make sure that our work is relevant and contextual to the activities and risks that the organization actually faces. So when it comes to training, we train on things that we actually do, not just on rules that we're subject to. When we provide advice or do other kinds of activities that are about the work of the agency, I think that's a great place to start. But what's something we need to be able to do or know in order to do that? If our work is going to be about the agency's work, what do we need to do? Yeah. Exactly. We have to do two things. One, we have to find out what's going on here, right? We need to find out what's happening in our agency. What's the upcoming work? What kinds of initiatives are underway? Who's doing what, and where are the risks? And we have to find out, what kinds of things could go wrong. And if something's gone wrong before, how do we take steps to manage that risk? And that's really what we're being asked to do with the Enterprise Risk Management Initiative, is to work together to see across the organization and identify the kinds of risks that we're best able to see, so that we can take steps to manage them. That's an excellent suggestion. So let's sort of move on and start talking about how you really do this. I've been to a lot of presentations about enterprise risk management, and people tell you about why it's a great idea, why it makes sense, and I agree those things are all true, but you never really get to the part where, how do you do it, right? What's the first step? What do we actually do when we sit down to do enterprise risk management, and how does that work? So we want to give you some sensibilities about where you can begin and be prepared when your agency calls on you to help them create their risk portfolio. So the first thing we want to do is find out where risk lives. If we're going to manage a risk, we have to identify it. So what we want to do is think about where and what kinds of organizations face reputational risk, and what are the features of those organizations. So if we're looking at the org chart saying, I want to find out where I need more information, what I'm concerned about. How do we know where to start? How do we know where to look? Does anyone have any thoughts? Yes, we'll see. Okay. Okay. Absolutely. So anytime we have a lot of money or resources or people moving around, there is the potential for risk. If we're handing out grants, if we're engaged in contracting, if we're doing enterprise infrastructure analyses or upgrades, all of those things, when you have those kinds of changes, pose risks. Anyone have any other thoughts? Yes, please. Okay. Absolutely. So we're not going to be able to do this by ourselves. We need information that people have that we don't have. And I think you're exactly right. The middle managers are people who really do have this information. They can help us. They can share that information. They can point us in the right direction. And to get that, we're going to have to engage with them. I think that's a great first step. Okay. Right. Okay. So there are a few things in there. Stuart suggested where we have people who are distant, either physically distant or organizationally distant from support and oversight, we have risk. When we have people who are moving quickly, when you have a reduction in time frames, when you have tight deadlines, when you have a sense of we just really need to get this done, there's elevated risk. So yeah, those are absolutely factors we want to think about. Yes, please. Right. Absolutely. So anytime we have big work that touches outside organizations, so if we're regulating or we're overseeing or investigating, there's risk there, right? Because we could have conflicts of interest, we could have inappropriate sharing of information, all sorts of things. Absolutely. Yes, please. Absolutely. When we have turnover, we have succession, when we have new people coming in who maybe aren't inured to your agency's ethical culture or culture in general, maybe they're unfamiliar with the processes and procedures that are in place. So yeah, there's a lot of risk when we have turnover. And I think Walt said this morning that the nation is most vulnerable during a time of transition because bad things can happen without the right people being in the right positions. So yeah, absolutely. Any other places we might find risk? Yes, please. Yes. Yep. So when our work touches outside organizations or individuals, yeah, we have potential for risk there. Yes, please. Yes. Yeah, so anytime we have a legal proceeding, you know, there's legal risk there certainly, but there could be material and reputational risk as well. So yeah, you know, that has to be part of the portfolio. We could definitely have possibility for conflicts. Yes, please. Yes. Fantastic. That is the $64,000 question, right? Because really, anytime we're doing anything that's of significant interest to anyone else, there is risk. And risk doesn't mean we shouldn't do it. It doesn't mean that we should stop. It means that we should think about it. And you're getting at the sort of the next thing that we need to talk about is how do we know where to start? How do we prioritize risk? It's not enough just to say, yeah, that's risky, that's risky, that's risky, that's risky, that's risky. We must deal with all of these things. We have to say, this is the most risky thing we're going to do. So we're going to make sure we deal with that first. And we need a proportionality of response, right? When we leave the house every day, we face all sorts of risks and we take necessary precautions to manage them. And that's what we want to do as organizations, is to have a proportional response and a well thought out and prioritized response. So in a minute, we're going to look at a framework for relative prioritization of risk so that we can decide where we start. But thank you. That's a great question. So just to sort of review, where our work affects outside entities, where we have infrequent oversight, isolation from guidance infrastructure, geographic isolation, punitive decision-making environments. So you guys identified, I think, all of these. So you know how to do this. It's a question of what do we do now? What's the next step? Let's talk just briefly about when we find risk. So we talked about some of the features where if we have static risks, what kinds of things do you think over time create risk? We identify one. We're going to have a big change in leadership in just a minute. That's going to be a major temporal source of risk. Where else? Yes, Jenny. Crises, yeah. Something really bad happens and we have to move quickly. We have to address circumstances we don't control and maybe aren't prepared for. That's definitely a major source of risk. Yes, please. Budget pressures. Yeah, when our resources are being reduced or we're competing for resources, the temptation to engage and maybe cut corners is significant. Yes, please. Scrutiny itself can cause a risk, because we feel a lot of pressure. And I think that's an important feature of risk management, is to look at who's under the most pressure right now. And when you have people making decisions that are significant, that are going to result in consequences one way or the other, you definitely have risk. Yes, please. Yeah, when we have sort of a culture that has stagnated. That's I think that's a really important thing. When we look at some of the recent scandals, going back over the last 10 or 15 years, sometimes you find an office has sort of moved culturally away from the compliance culture of their larger organization and have been sort of entrenched in doing things the wrong way. Or maybe they don't realize that there's risk in the work they're doing because they do it so frequently. So I think, yeah, there's a risk in complacency as well as a risk in change. Any other suggestions? I think those are pretty good. You guys are good at finding the risks, so I want to help you. So yeah, increases in workload, nearing deadlines. So these are kinds of pressures. Change in leadership, reorganization, reductions in force. When you have fewer people doing more work, the tendency to maybe cut corners increases. So yeah, so you guys are good at identifying these risks, and it's something we always need to be doing. But what we really want to do is use that information for something that benefits our organizations. So how do we do that? How do we use this information? Because as you rightly pointed out, everything is risky to some degree, right? Every time we leave the house, every time we turn on the computer and send an email, there's a risk, and we need to make proportional decisions. So how do we prioritize those things? I want to suggest a grid that you can use to start to think about prioritizing risk. And then look at a couple of examples of risks that we face outside of the workplace and how we address them. So I can't take credit for inventing this framework. It's used by a lot of people. I think it dates back to a decision by Judge Learned Hand in a maritime liability case establishing duty of care. But basically, we have two axes. We have the magnitude of the risk, the magnitude of the effect, and the probability of the occurrence. So this gives us two measures that can help us determine where to focus our efforts to manage a risk. So we can figure out sort of the relative magnitude of a risk by using these two features. So we have some examples here. On the left-hand column, we have something that you could imagine happening in your home, which is something like a house fire. What are the odds in a given year that you're going to experience a house fire? Relatively small, right? Not zero, but relatively small. And what is the significance to you as the owner of the home if your house were to catch on fire? So there's a significant magnitude. Yeah, it's maybe not the worst thing that could happen to you, but it's really not a good thing. So we have a low probability, high magnitude risk when we look at a house fire. And what kinds of things do we do to manage the risk of a house fire? We have insurance. Yep, absolutely. We have insurance. We have smoke detectors. Yeah, twice a year, we make sure the batteries work in the smoke detectors. What else do we do? Exactly. And if you're anything like me, I finish cooking dinner, and if I am going out after dinner, I go, I left the gas on. but we worry about these things. Yeah, we try and manage the obvious things. So these aren't remarkably expensive activities, and they're not enormously inconvenient. They're not enormously resource intensive, but they're proportional to the risk. We've sort of decided collectively that having smoke detectors, fire extinguishers, insurance, and generally being mindful is a good way to manage that risk. What about these other things, these high probability, low magnitude things, like a pest infestation? Right? What are the odds that you have a mouse or an unwanted insect in your house over the course of a year? They're pretty close to 1, aren't they? It's very, very likely that this is going to occur. And so what's the significance of that? Is that a huge magnitude event, or is it sort of an inconvenience? It's an inconvenience, right? The world doesn't end because you have a mouse. Someone might scream, but that's probably as bad as it's going to get. So what kinds of steps do we take to manage a pest infestation? If we have mouse traps, we might address it after the fact. We might keep mouse traps on hand. Other things, you might have someone come spray your yard every now and again. You might have homeowners insurance in case you get termites or something like that. That could be a big or small magnitude effect. So proportionally, we take steps that are roughly similar between these two risks, even though they're very different in kind. But even though they're very distinct risks, we're able to analyze them on this grid and find out that they're actually similar in magnitude overall, even though one's a high probability, low magnitude, and the other's a high magnitude, low probability. So I suggest to you that this is a place to begin. And in a lot of manuals for managing organizational risk, they suggest a similar framework, that you measure the probability against the magnitude. And you could do this in a grid format. You could have low, low, high, high, low, high, or high, low, which would give you at least 3 categories. You could get more granular. You could put everything on a scale of 1 to 10. But the important thing is that you have a standard framework that allows you to compare disparate risks against each other. So let's take a look at how this might work in the workplace. So here we have sort of similar kinds of risks. On the left there, we have high magnitude effects, like a major conflict of interest in a big procurement or other government matter. Is that a really bad thing for your organization potentially? Yeah, that could be really bad. What's the worst thing that happens if you find out someone's had a significant conflict? What could happen? Our employee could go to jail. That's very bad, very high magnitude for our employee. How about for the organization? Second, we might have to recompete some things. Maybe not just one thing, but maybe everything that person's worked on for a long time. What other things might happen? Yeah, no, you could have a major organizational disruption, right? You could be participating in meaningful oversight activities on the other end of Pennsylvania Avenue until you can't remember a time before that. Other suggestions? Yeah, no, you could be preparing for hearings, for audits. A lot of disruptive things could occur if you have a major ethics issue. Is this a super high probability situation for your organization? This doesn't happen every year. I hope it doesn't happen every year. No, but we take steps, we take meaningful steps to prevent these problems. What kind of steps do we take to avoid conflicts of interest? Yeah, we do training. We do financial disclosure review. We provide advice and counsel. We do a lot of things to manage that risk, even though it's a low probability, because it's such a high magnitude. We invest a lot of resources in managing that risk. And that's a risk that should be considered in your agency's portfolio of risk. How about these other things? So here we have maybe the misuse of the agency copy machine. Someone's borrowing office supplies. I'm sure they intend to bring them back, but maybe they don't get brought back. Someone enjoys a continental lunch or breakfast that maybe was paid for by someone they should not. What do you think the odds of these things happening in your organization of a given year are? Yeah, they're approaching 1. I don't know. You might have a really good lock on your supply room door, but I bet you have at least someone who borrows a pencil and doesn't give it back. So these are sort of high probability situations. And what is the magnitude? Do these usually result in those really bad circumstances we were just discussing? Not on their own. In the aggregate, they can erode the culture and pose serious problems to us. But in the sort of individual, the magnitude isn't what it would be if we're going to blow up a major procurement or have a major issue of fraud or conflict of interest. So what kind of steps do we take to manage these risks? We do a lot of training, right? How many people send reminders periodically for sort of seasonal risks like this? Yeah, no, so we take steps that are proportional to the risk, and we're able to see that these are disparate risks, but we can compare them against each other. So what we'd like to suggest is that you can use this framework to look across your organization and categorize risks from an ethics perspective. So you could have a piece of proposed work. So we're discussing that everything we do comes with some degree of risk. So what kinds of activities might we be engaged in that bring with them a high magnitude, low probability risk? What kinds of work maybe happens at your agency that really has the possibility that if it goes wrong, it could go very, very wrong? Yes, please. Absolutely. When we're buying something, we're doing a major procurement, we're going to spend a lot of money. If we had a conflict of interest as a part of that, the magnitude is going to be huge for us. And if we get it wrong, the cleanup could take a long time. So that's a place where we could say, yeah, there's a high magnitude risk there. And we want to make sure that we take steps to address it in the context of that work. So yeah, no, I think that's a good suggestion. Other work. Okay, implementing a new program, right? If we're implementing new legislation or new responsibilities, we're doing something for the first time, maybe it's publicly controversial, we want to be very, very careful because any misstep could be very, very problematic. Other things. Yes, please. Okay, so enforcement actions, if we're engaged in enforcement or prosecutions, if we're engaged in litigation, we have a potential for a problem if we have a conflict of interest or other ethics concern. So I think you guys are sort of getting the point that when we look at the work of the agency, we can contribute as ethics officials to help leaders and groups of leaders understand the risks that come from the work. So in a major procurement, we could have other risks, right? The ethics risks aren't the only risks that come with that. What other kinds of risks does the organization face when we spend large amounts of money? We could get the wrong stuff. Yeah, we could we could fail in our market research phase. What else could happen? Yeah, we could lose funding over the process. We could be too slow. Other things. If we're doing an IT system, right? You suggested the CIO is a partner of ours. There's an information security risk that comes with that, and we do a lot of work to manage that. But the idea is that we get together as organizations and think about these in a portfolio way. So when we're looking at that major procurement, we as ethics officials are contributing a perspective on the ethics risk, just like the CIO is contributing the information security risk, and our procurement folks are talking about the budget security, and our budget people are talking about making sure we have the funding. And all of those things should go into determining what kind of work poses the greatest risk. Does that kind of make sense? Is this becoming more actionable? So these are the kinds of things that we might want to do. So these are the activities. The first thing we want to do is take a periodic assessment. We want to think about periodically the work that our agency is doing and seeing if we have risk that we can identify and contribute to the risk conversation. We've talked a lot about the other people we need to talk to. We have to talk to the people who are directing the work, who are deciding on what we're going to do, who are funding the work, who are managing other kinds of risks. So we're going to need to partner with others in our organization. And we need to deploy our resources strategically. That's what this is really about, is deciding where do we start? What do we do first? In the case of maybe a major enterprise procurement, the example we were using a minute ago, what kinds of things might we do as ethics officials to manage the risk of conflict of interest in that case? Please. Absolutely. We can give them a timely briefing about the work that they're about to undertake. We can make sure that we get in touch with everyone who's going to be in the room making the decision and make sure that they understand their obligation. What else could we do? Yes, please. Absolutely. We could crack open the financial disclosure files, even if it's not February or May, and take a look at them and say, is there anything here that suggests we might have a problem with an individual? And make sure that everyone is up to date and cleared before they start participating. It's a great suggestion. Any other suggestions? I think those are a really, really good place to start. And that seems proportional to the kind of work we're doing. And that's a strategic deployment of our resources. Something else I think that we're getting at is timeliness. Reviewing the financial disclosure report before you know who's going to be on the procurement doesn't help us with that procurement. It doesn't help us with that piece of work. So we need our work to not just be effective and properly directed, but also timely. And the way we do that is we have to find out what's going on and when. And to do that, we're going to need to reach out to managers so they come to us and ask for help. That'd be a great situation, right? The head of this procurement comes to you and says, you know, I'm about to select people for the source selection committee. I'd like you guys to help me look at their 450s. Or I'd like you to come to our staff meeting and make sure everyone understands the rules. That's a great place to be in. But they have to understand that service is available. Our employee training, we can attune employees to know when they need help and when they're facing risk. And ethics reminders. You know, we talked about those things that happen seasonally. We can send out reminders. And actually, there's a lot of research that suggests the timeliness of an intervention is more important than the duration. So there have been some studies done in organizations about whether it's better to give someone like days on end of ethics training at the beginning of the year as sort of an inoculation, or if it's better to remind them periodically that the organization's paying attention. And a well-timed email is actually more effective in many cases than a 2-day class that's 6 months before the fact. You know, so simply reminding people before they go into the source selection or before they engage in some risky work can be extremely helpful, and it can also save us a lot of resources. And something else we want to talk about, and I think you suggested this earlier, is we need to think about what happened last time something went wrong. Were we prepared? Did we do the right thing? And you don't have to wait for something to go wrong to figure out if your systems are proportional and correct. You can imagine before we're undertaking this major procurement or other major initiative, would we be able to explain to someone what our risk management strategies are? And would they be able to understand that those are sufficient and proportional to manage the risk? Right, so you can think about, you know, can you explain your thinking and your decision-making and your judgment to another person? And if you find that actually the activities that we're undertaking don't seem proportional, or someone else wouldn't find them to be proportional, maybe you want to think about them again. So that's an interesting perspective. It's to say, you know, imagine this risk came about. Did we do what it seems is necessary or proportional to manage the risk, right? So we can't manage everything to zero. I think this comes to the relative resource deployment. You know, it's like, when do we feel comfortable with the level of risk? So I think, you know, in the case of the procurement, we had 2 strategies we identified. One of which was timely briefings, and the other was scrubs of the financial disclosure reports. In certain circumstances, one of those might be adequate. In certain circumstances, 2 might be the bare minimum, you know, depending on the magnitude of the problem or possible problem. So another thing we can think about is identifying, and this is something that we like to talk about when training managers, is can you find employees who are going to find themselves in a tough spot? So this is sort of when we take the enterprise out and think about managing on a small scale. So I'll ask you guys, what do you think causes ethics risk for individual employees? What kinds of circumstances do employees find themselves in that put them at risk? Financial distress, absolutely. Anything else? Other suggestions? So yeah, an employee who's facing personal financial stress, that's potentially problematic. Okay, employees who have multiple priorities and maybe have work outside of the agency, you know, that's potentially an individual circumstance that's problematic or poses risk. Yes, please. Okay. So yeah, employees new to federal service. Yes, please. Absolutely. Employees who have responsibilities that affect outside entities. Absolutely. Yes, please. Employees who have significant sort of personal authority. Contracts are an example, but other kinds of discretion without oversight. That's definitely an area where you could have risk. Others. Yes, please. Okay. Yeah. So employees who work in organizations that don't have a culture or leadership that's supportive of ethics or supportive of compliance. So I like to think of the employee whose boss just said, I don't care how it gets done, just make sure it does get done. That's an employee who's just become at risk. So I think you're exactly right. Other sort of indicators of risk. Yes, please. Right. Good. So employees who are out interfacing with industry or government contractors who in either a social or sort of non-work environment, there are risks there. Absolutely. What about someone who's just been promoted? That's a good thing. We want our employees to be promoted, but do you think there's additional risk there? Yeah, there's a learning curve and there's a desire to get it right the first time, right? There might be a reticence to say, hey, I need help. I need help from other parts of the organization. Other circumstances. That's a pretty good list. And if you think about the ethics program and how it addresses some of these risks, I think you'll see that there's a lot of risk management already in the ethics regulations. Who has to file 450s? Those people whose jobs touch outside folks, the people who have significant discretion, the people who are empowered with a lot of government authority. These are the same people who have to get annual training. So, there's some of this is baked into our programs and we don't see it because we work with it every day, but I think it's helpful to step back and see it. So this I stole from GAO, mostly so you don't think I make all of this stuff up. There are other people thinking about this. So when they are doing fraud investigations, they have this thing they call the fraud triangle, which helps them see whether an employee is at risk for committing fraud. And they see that there are sort of three functions. There's opportunity, incentive, and rationalization. And I think this is sort of helpful for us. It can help us to identify people who occupy positions that put them at risk. So are they distant from oversight? Do they have some stress that gives them a reason to maybe cut corners? And is there a way that they could rationalize that? So, this is a feature that audit folks are familiar with. I think for at least fluency, it's useful for us as ethics officials to have a passing familiarity. Sort of in the vein of working with others in our organization to manage risk. Yeah, so we have some strategies. We need to talk to managers. When we're talking about employees, it's impossible for us as an organization, right, to know which individual in the organization is at risk at all times, right? We can't do that. That's impossible. But what we can do is when we're training managers, we can help them spot these situations. So if you have someone who's in a tough spot, and sometimes it's necessary, right? Sometimes people work in pressure cookers. They do hard jobs that have to get done. They have strict deadlines. The deadlines, we didn't invent them. They really exist. And that's challenging. And the best thing we can do as organizations is help to recognize that and support those employees and remind them of the obligations and tell them that the organization supports them in meeting those obligations. So, I think this is a good thing when you're training managers to think about. We can also allocate our education resources strategically. So when you're looking at the risk profile of the agency, you can say, this year, I can't provide specialized training to everyone who has to receive training this year. Right? Does anyone have that luxury? You can provide specialized briefings to every group of employees that might need it. You're very fortunate. We have one hand. No, we understand that that's not always possible, and we have to prioritize. So what you want to do is use good data to decide where to spend your resources. So if we were going to do this big enterprise procurement, we might spend our resources giving those folks a special briefing. And we might say, those people who are doing work that sometimes is a major issue isn't this year, so we're going to give them the standard briefing. So we can use this information to deploy our resources strategically, and we can be timely. I think when we consider what it means to intervene in the situation, we overestimate things. You know, we think that everything has to be a big resource allocation, that I have to do an hour-long briefing. How long would it take you to stop by and remind the source selection team in our big procurement of the ethics rules and the general concept of a conflict of interest? If you wanted, how many minutes would you ask for at the beginning of a staff meeting to do that? 10, 15 minutes, maybe less, maybe 5 minutes. Would 5 minutes be better than nothing? You just stop by. You say, remember, conflicts of interest are important. You guys all file 450s. If anything's changed or you have a concern, come talk to us. Right? You could do that way less than 5 minutes. And if you had one employee come to you and seek advice because they had a real conflict, that's 5 minutes really, really well spent. So when you think about, you know, what does it mean to address a risk, you don't have to think it has to be a major campaign. There are lots of small incremental investments that we can make that can really make a difference. So, you know, I'd encourage you to think not just enormous, but also small. Any other thoughts on that? So we've provided you guys some paper that you can use. How are we doing for time? We have a little bit of time. We can just sort of open it up and discuss what we might do with this. But this is sort of the process that you might find to be helpful, is to start by identifying some risks that you think you're going to face over the next quarter, 6 months, a year. Planning on a fiscal year basis is good because that's what your performance people do. And just think about, you know, what are the top 3? And then the next part of the strategy is to think about prioritizing them using that framework of magnitude versus probability. And then we can talk about some strategies. So maybe I'll give you guys 10 minutes. And if you could just think about maybe 2 risks that your organization is going to face over the next year, and think about whether they're high magnitude, high probability, low magnitude, low probability, and sort of practice prioritizing them. So we'll take 10 minutes or so. And feel free to talk to each other. It's okay. This is another obstacle that I found doing these briefings is when you engage in a risk assessment, you have to name the risks. And sometimes that in itself can be a little bit scary. So no one can see you. Would anyone like to volunteer something that they're, you know, thinking about over the next little bit of, yes, please. Okay. Right. 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 Absolutely. So we have I think it's at this point a certainty of a significant turnover, right? We're facing sort of a generational change in the government workforce, where we're not just going to have changes at the political level, but a significant number of career officials are going to eventually retire, and they're going to be replaced by people who are by definition less experienced. So would you guys put that as a low, medium, or high probability event? It's going to happen. This is an easy one, right? Yeah, this is a high probability event. How about the magnitude? How would you sort of assess the magnitude of the risk? I think it is too. Right. 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 Yeah, so we need greater granularity in the naming of the risk, right? The turnover of the head of procurement in our organization is probably a much higher magnitude risk proposition than the turnover of the agency photography office, who comes and takes pictures of the secretary giving speeches, right? Both important jobs. One of them comes with a lot more risk. So, you know, that's great. So we determined the magnitude, and we said we need greater granularity to make a relative judgment. Fantastic. Other risks, yes, please. Okay, is a risk, a huge risk. Okay, so you have a situation where you have maybe do you have turnover in the human resources area, or just a lack of cooperation? Okay, so we have a risk to the ethics program itself in this case, right? So we potentially, and the risk comes from partners outside the organization who are maybe not as cooperative as we'd like them to be. So yeah, that's a risk, and I take it in your case the probability of this eventuality is high. It may be, it may be an existent situation, right, where it exists, and okay. Okay. So you have both sort of a risk and a challenge, or you have a lack of organizational willingness to maybe address or to mitigate issues, and then you also might have a concern that people aren't providing you the information that your program needs to function properly. You know, I think that would be a serious risk. And how would you sort of rank that if you were looking at it? You know, what are the potential magnitude points if that comes to fruition? Okay, so it's very probable. And what are some of the really bad things that could come out of that? You know, what's the potential for problem? What is the magnitude of the problems that could arise? Yes. Very good. Yeah. Right. To be catastrophic, truly catastrophic. Absolutely. So yeah, I think that's exactly the kind of risk that, one, you want to name, and by naming it, you may find that the organizational elements that are resistant to thinking about it become more inclined to do so. But I think, you know, that's a good example. Do we have any other risks that we want to talk about? Yes, please. Okay. Right. Absolutely. So we have a huge population of people in DC at senior positions in government who are right now, whether they say it or not, thinking really hard about what next job they're going to be doing. And that could take the form of seeking employment or negotiating for employment and eventually post-employment. So that's a major risk. What's the probability there? Yeah, it's high. The probability is almost 1, if not 1. And what's the magnitude? What kind of medium? Okay, no, I think that's a very fair assessment. So what kind of strategies might we undertake to kind of address that? Yeah. Yeah, I think this is a really good example of a place where timely reminders can be very helpful. You know, you could just send out an email, remind people if you're thinking about the next step. We are here to help you navigate that process. Make them aware that someone's paying attention, that someone's identified the issue, and that there are resources available to help manage that. From an individual perspective, this is kind of interesting. You're talking about employees individually who are in difficult circumstances. You know, what kind of stressors are individuals facing here? I'm a Schedule C. My job's done in 9 months. I don't know what's coming next. Yeah, so there's some financial stress that people are experiencing, and I think, you know, that contributes to our ability to address the risk. That's great. Any others? Yes, please. Yes. Okay. Okay, so you have people who are governed by a regulatory framework that they don't always think about and they may not be really familiar with. And that puts them individually at risk, and it puts your organization at risk, because if you have misconduct, that's a problem. So the fact that these people face the risk, the probability, again, is very high, and the magnitude of the effect could be significant. Yeah, absolutely, both for the agency and the individuals. So what kind of strategies are you guys using to manage that risk? Hoping it goes away. Yep. Right, I see. Yes. Right. 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 Well, that's great. So even within that risk, you've undertaken a sort of a more elemental analysis and said these particular individuals have the potential to cause damage to our agency. So you're focusing your resources there while also managing that low-level risk with reminders. That's great. That's exactly what we're trying to do. Any others? Yes, please. Yeah. The possibility of a temporary lapse in appropriations, I think, is the parlance. But yeah, I think anytime that we have budget uncertainty, there's all sorts of risks that come out of that. You know, the probability of that in a given year, high, low, medium. In any given year, it's probably low to medium, but it causes some problems, right? You know, there are lots of risks that come out of it. We hurry to get work done. We struggle with plans to orderly reduce operations. We worry about the continuity of programs that are ongoing. So yeah, there's lots of risk there, and the magnitude could be anywhere from inconveniencing some people to really big, serious problems for our agency and our country. So it's a good suggestion. Any others? You guys are great. It's very late in the day. And any other suggestions? No, but I think you kind of get the idea. Is, you know, what we're encouraging you to do is keep your eyes open, sort of be anticipating these things, take steps that are appropriate to address those things, and most importantly, work with the people in your organizations to do this as an organization. We want the ethics program to contribute to the risk management exercises at your agencies. We want you to be partners. You have a unique perspective. Your organizations need you to bring that to them because they don't have the expertise, and they have information that you really need in order to exercise your expertise effectively. And I think when OMB's guidance and training comes out, you'll see that there are opportunities for you to engage in that process, and hopefully you feel prepared to do that, and you have a vocabulary that will be helpful when discussing this with people who do this for a living. So, you know, I hope this is helpful to you guys. And I think these slides will be available, but this is some reading I have done on this topic. If you're interested, there's a lot more than this. You could read about enterprise risk management, organizational risk for a very long time, but taking a look at some of it is very helpful because, again, it gives you a shared vocabulary with your performance community, with your chief financial officer, with your CIO. You have a way to begin a conversation, and you can really contribute and meaningfully help your organization manage its risk, and hopefully protect our government programs and operations. So thank you guys very much. I hope you find this helpful. I hope you feel prepared. I hope you're looking out for the latest guidance from OMB. When that comes out, we're going to find ways to get that to you, tell you what the specific action items are, and make sure you're as prepared as you can be. So have a great evening, and I hope to see you tomorrow. Sure. Sure. So this is a little bit tricky because I've seen the final, it's not been published yet, so I've seen the comment. And basically, the things that we've asked them to do is to include reputational risk as one of the risks that agencies should consider in their portfolios, and also to encourage engagement by the ethics office in the risk process.
So what currently exists for OMB guidance is A123?
Yes, that hasn't been updated in more than a decade.
Does that address agency ethics risk management or the agency's